set, we set a sentence date after you pled guilty to failure to submit to testing. You were going to go to your doctor. Did you go there?
I did. It was yesterday.
Did he give you a report?
He gave me just basically like a note. I tried to
Do
read
you have it with you?
I sent it to Emily this morning. It was just like I saw you yesterday, though it wasn't much. So I did reach out. They don't know if there's like 9 to get you a report. She's on there. And then they gave me a prescription for something that she said was fine.
So is he saying that you've got shy bladder syndrome?
That and it's hard to word it.
All right, let me get her in here. And we'll see what the letter says.
It was basically I saw you yesterday. That was just gonna show you much.
Well, that isn't enough.
I know it's not. That's why I said I reached back out already.
I need shy bladder syndrome diagnosis.
You did say it a few times, which is not no.
It just says, I saw you yesterday.
Pretty much. I saw you this person on the 24th.
Let me see what we can do here, okay? Just give me 1 second. See. If you need those or not. Unless I keep a couple up here, I could. Okay. Okay.
You want me to come here?
All right. So first of all, let me tell you something. You have a right to a lawyer. I'll be happy to provide you with one at public expense if you would like one. Would you like a lawyer to represent you?
Yes.
Pardon? Okay. So let me see what she has to say. Do you have anything to say?
No. They have to go away.
Okay. Why don't you have a seat? Just have a seat until she gets back. You know, okay? Thanks. You can sit right there at the table if you'd like.
See. Yeah. Yeah.
All right. Do we have this other gentleman's case here, John, or not?
Yes, he has a case with the state prosecutor field.
All right, recalling Eric Stefan Kish, 25F244490. Mr. Sino, your name?
Emily Tessino.
Sir, your name?
There it is.
All right, you still wish to waive your right to a lawyer? And you don't have anything to say? He says he got a letter from his doctor just saying he was there. That wasn't the point.
That's what I said. I think I responded and said he didn't give you any other information. He said that he gave him a prescription and I looked it up and it, or he's giving you a prescription. Yeah, so I looked it up and what it says the prescription does relate to the testing issue.
Does?
Yes,
It's gonna help him urinate.
yes.
Well, then let's set this for sentencing again. I'm sorry. If you want to go back and get the diagnosis of shy bladder syndrome, I'll require DNA. Is that where you're testing primarily?
Yeah.
And all his testing has been fine since. He went the 3rd, the 8th, 12th, the 16th, the 18th, and the 23rd.
You've been testing all those times?
I tested every time. I only missed the one due to this. I go back a lot of this, and like I'll go in the morning and usually go and pop back up later. But
Look, let's just do this.
someday it was 3 attempts. I was there for nothing.
So all those tests have been negative.
Negative, and he's on the sober league as well.
Good enough. I'm gonna assess costs of $50. You pay that now, I'll keep you on probation. Just make sure you're going, okay? If not, I'm gonna need a diagnosis of shy bladder syndrome, then I'll have them do a pat-down search. Okay. We didn't advise them to do a pat-down. I remember doing that
We
on,
talked about seeing if it helped, but we didn't.
okay,
So I'm hoping that the medication helps and.
good enough. Good enough.
Okay.
Thank you. Good luck. Thanks a lot. Have a nice Thanksgiving. Lexi Jane Elaine Don, 25B 724-898.
James Jeremiah on behalf of Ms. Don, who I believe is going to be present by Zoom this morning.
All right. I'm not. They didn't change anything, right?
They did, Your Honor. They changed it from a requirement to a strong recommendation, which I don't
Hang on.
know. And but they should have, unless I gave you the wrong floor, which,
It was dated today.
okay. Yeah, I may have signed the wrong form. I double check it, Judge. Make sure I did print the sign.
I mean, let me take a look. Give me 1 sec.
Okay.
Mr. Mohammed, how are you this morning? Good, thanks. Wait. I want you to come here, please. Ma'am, your name?
My name is Lexi Dan, Your Honor.
Whoever has that phone.
You have to take that out of here, please, sir.
Yeah.
If the defendant, Mr. Mohammed, your name?
Good morning, Your Honor. Mohammed, happy people.
If the defendant fails out of the sobriety or specialty court due to poor performance, commits another crime while on probation recommendation, or the judge finds sufficient cause to terminate probation, then the balance of the year or 1 year must be served in jail, no work release or waiver.
Your Honor, I may have printed and signed the wrong form. Can I double check that?
Yeah,
My fault. I don't want to get Mr. Mohammed in trouble.
Well, nobody's getting anybody in trouble. I just still don't feel comfortable if that's the best we can do. So we'll have to go to the exam. The exam's today, right?
So Judge, that was amended to a strong recommendation, and that portion is not part of a sentence agreement. I'm assuming that form is the old copy.
No, it is it does say strong recommendation on the top. So I think the idea is, Your Honor.
Guys, I don't mean to be rude. Like, how can I read this different than I'm reading? I can't.
Judge, it's not a sentence.
Listen. You said, under strong recommendation?
Yes. It's.
Hang on.
So if I could, Your Honor, I think the idea, okay, sorry.
You know what the idea is. I am not going to ever put myself in a position where somebody says the judge sanctioned this plea agreement and then didn't follow through. I want you to hear me clearly. Nobody's ever going to be able to say that I took a plea. There was an agreement in place. Now, it might say strong recommendation on the left, but any judge reading this, quite honestly, including this one, if the defendant, it's a strong recommendation. I'll give you that in bolds. If the defendant fails out of the sobriety or specialty court due to poor performance, comma, commits another crime while on probation, parents, recommendation, and parents, or the judge finds sufficient cause to terminate probation and the balance of the year or 1 year must be served in jail, no work release or waiver. Now, what does that mean? I know what it means. I don't feel comfortable doing this, guys. If you want to redo this language and just say, then the prosecutor's office, if the defendant fails out of the sobriety or specialty court due to poor performance, commits another crime while on probation, or the judge finds sufficient cause to terminate probation, the Wayne County Prosecutor's Office stipulates in the Wayne County Prosecutor's Office recommends it that the balance of the year or 1 year should be served in jail. However, the Wayne County Prosecutor's Office leaves this to the court's discretion. I mean, I'm not going to go through with this, guys. I told you, I mean, I'm going to give you the example again. Somebody is 95% compliant and they screw up at the end. They have an addiction. They've done a good job, but they lost it again at the end. I've seen it. It happens. I'm not going to have somebody tell me you have to give them a year in jail. I still go back to what I said. And look, it's okay that we disagree. Maybe you guys need to go to the Wayne County Circuit Court, sobriety court, probation. I have no problem with that. You can waive the exam. I happen to think ours is as good as any around, but I'm a little biased. So if that sounds arrogant, forgive me. But I will do this under these circumstances with this language in it unless it's clear and unambiguous that this is in the court's discretion. And to the extent somebody can't say that, I understand. It's okay. We'll just agree to disagree. But I can't have somebody tell me this says that it's a recommendation. I realize it's a strong recommendation. And then, by the way, you got on the back here, courtroom APA must be notified if any of the 1 year jail sentence triggers are committed. Now, maybe there's judges that'll read it more liberally. God bless them. It's okay. Everybody doesn't have to agree with me. Everybody, every day, people don't agree with that. It's okay. I get it. They don't have to. Ms. Don, I am so sorry. I don't know what to tell you. You guys can work on this if you want. You can pen it in. You can redo it. You can do what you want. If the office is going to say, Judge, that's the best we can do, then I'm going to say to you, I'm sorry, I'm not doing it. We're going to the exam at 11 a.m. today.
Judge,
Judge, I may, just in regards to that portion, we are leaving that to the discretion of the court.
You got to write it in here. I'm not going to go searching for transcripts. This does not look like.
But that's why it was written as a recommendation and not.
You wrote it as a strong recommendation. You put it in the caption, but then it reads like the judge has to do this. I mean, if you can't, listen, I'm not trying to pressure anybody or make anybody feel bad or anything else. This seems like a nice lady here. I'd love to have her in our sobriety court. I think she would be a great candidate. But I feel so strongly about this, and it's not some kind of just an argument. I don't need to argue with anybody at my age, but I just can't do it. So you guys are either going to have to fix it or we're going to exam at 11. Sorry.
no problem. If we can have it back, and hopefully we can fix it.
Okay. Hagan Lee, John, can you handle that, please? Hagan Lee Trackwell, 24B714693. Again, Mr. Muhammad, I want to be clear. If you guys just don't want to do it, it's okay. You're not hurting my feelings. You're not.
I understand.
I'm just,
It goes through my supervisor.
I know, I get it. I get it. Come on up to the podium if you would, Mr. Trackwell. Mr. Trackwell,
Yes, sir.
where were you?
I was just calling there sometimes, I was.
All right, okay, let me talk to your lawyer. Counsel, your appearance.
Good morning, Your Honor. Attorney Corey Westmoreland, Great Mill, get out of Machine Back. Well,
Okay, so you didn't show up here for your date on October the 23. So why didn't he show up for his November 23 date, counsel? Can you tell me?
Your Honor, I just had my car repo. I had no way.
Where do you live? You live in Brownstown.
Yeah,
How far do you live from here?
like 15 minutes.
All right, well, how'd you get here today?
I got a ride from my mother.
Why didn't you get a ride from your mother on October the 23rd or take an Uber or take a cab or take a Lyft?
Right before my car got repo.
Calling Jessica.
Trying to make sure my girl was gonna get to her OB.
All right, I'm gonna let it go. You can't do this, son.
Yes, Your Honor.
You can't do this. You walk in here 5 weeks later. What if I wasn't here?
Yes, Your Honor.
That'd be rude if I wasn't here since October 23rd and then decided to come in Monday and told you to come in. Counsel, there was no, disposition on this. The charge was failure to refrain from consuming alcohol or drugs, testing positive for cocaine on a chemical test. That's count 1. It's actually an amended show cause dated October the 16th. And then count 2 is failure to refrain from consuming alcohol or drugs, testing positive for alcohol and marijuana on a test of October 16th. So those are the 2 counts. Ms. O'Donnell, your name. Good morning to you. How is he going to proceed?
Yes, Your Honor. After speaking with Mr. Trackwell this morning, we are prepared to waive any sort of contested hearing on your guilty plea.
Is that what you want to do, sir?
Yes, sir.
You have 1 prior technical violation. This would make 3. I just want you to understand, you could get 15 days if you plead guilty to both of these. That would be 3 technical violations. Do you understand that?
Yes, sir.
Did you sign an advice? Did he sign an advice of rights form today?
I do.
You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena power of the court to bring in those witnesses. If you plead guilty, now wait before we go any further. I'm just going to orally advise you, then you can sign the form, okay? If you plead guilty, you're giving up all of those rights, including your right to a contested hearing. You have the right to remain silent at that hearing, and if you do, that silence would not be held against you. Do you understand?
Yes, sir.
If you plead guilty, we're going to have a disposition hearing, but we're not going to have a hearing as to these 2 counts if you plead guilty. Do you understand that?
Yes, sir.
Any questions before we go on? You understand everything?
Yes, sir.
There's the count 1 that you fail to refrain from consuming alcohol or drugs testing positive for cocaine on October 6th of 25. How do you plead?
Guilty, Your Honor.
Did you test positive on a chemical test on October 6th of 25 for cocaine?
Yes, sir.
Had you consumed cocaine within the preceding 72 hours?
Yes, sir.
As the count 2. Did you fail to refrain from consuming alcohol or drugs testing positive for alcohol and marijuana on a chemical test of October 16? How do you plead?
Guilty.
Did you test positive for alcohol and marijuana on that date? Hang on 1 second, just listen to my question. And did you consume alcohol and marijuana, say, within the 3 days preceding that, at least the alcohol?
Yeah.
Did you consume marijuana, say, within a week of that date?
No.
When did you consume marijuana?
It was probably a week prior from me seeing my probation officer, so.
Wait a minute. Let's talk about the test date of October 16th.
Yeah, marijuana was still in my system
Slow down.
from being.
Slow down. When did you last use marijuana? I sentenced you in this case on October 15th. I see. I see. But I told you not, Judge Hessen told you not to consume alcohol or marijuana on July 17th to 24, and you absconded, right? Right?
Oh,
On the bond.
yes.
You were told not to drink alcohol or consume marijuana, correct?
Yes.
And then you absconded for the longest time, right?
Yes.
And you realize those bond conditions were still in effect, right? She never lifted those, did she? She never told you
No.
to use marijuana and drink, did she?
No.
Are you on probation or parole for anything else?
No.
Anybody force you to plead guilty?
No.
I'm going to find you guilty if I find the plea has been made voluntarily and understandingly. Please accept it to being positive for cocaine and positive for alcohol. Cocaine being on October 6th test. Count 2 for alcohol, October 16th. There's still enough there to show that you at least violated a bond, but at least you're guilty of consuming alcohol. Now, look, this case was disposed of, or at least by plea, on October 1 of 24 after, I'm sorry, as a bench trial. And we are still wait a minute. I sent you October 15 of 24.
Yes. I only went for one director or something. Sure, yeah.
He was sentenced to probation on October 15th of 2024. He was on probation.
Right, and these tests happened on October 6th of 25.
A violation was issued back in September. He went into warrant status, turned himself in. He extended his probation 3 months. And then I issued this other violation October 23rd of 2025. He didn't appear. There was issued a warrant and he turned himself in today on that. And Judge, if I could, regarding the test on October 16th, he did go back after the fact, after I issued it, and did pay for the lab. He didn't pay for the lab confirmation on the marijuana, but he did pay for it on the alcohol. The alcohol confirmation did come back positive. ETG was greater than 10,000 and ETS was also greater than 10,000, Your Honor.
This is becoming complex, Mr. Trackwell. What do you have to say? Anything?
Your Honor, I would like to know that Mr. Trackwell did check himself into Corwell Lane Mental Hospital. He was there for approximately 4 days.
When was that?
I believe the 25th
Of what?
or the 22nd of this month.
Were you back in September at a mental health facility? Listen to my question.
Yes,
On September 2nd, were you in a mental health facility on or about that date? September 2nd?
I don't recall. I don't recall, Your Honor. They took me to court. Well, I was there for like 4 or 5 days.
And you're saying, but there's a note in here that you went to a mental health facility in September.
I probably did, but I just was there recently.
I understand.
Thank you, Mr. Rogers.
What else would you
Your
like?
Honor, he currently is looking for gainful employment. He's having a tough time doing so, being that he doesn't have a car. But he's looking to get his life back on track. He walked himself in here today, proceeding most of this was pending. He wants to clear this up. He does have strong family support. His mother and his girlfriend are currently in the courtroom.
Where? You're his mother? Come on up here. I don't usually do this, certainly not with somebody who's in their early 20s, but I want to talk to you. How are you?
Okay, how are you?
Good. Your name?
Janet Trackwell?
We got to get your son on track, so to speak. Okay? He's not doing it. I believe you. I don't know the extent of his issue, but he's ignored us. And he's not doing what he's supposed to do. Did you graduate high school? Do you have a GED?
I took the test.
That's great. He went up too. He's had
some history between myself and his father. His father does have addiction and mental health issues out of state, and he's not been consistent within his life. So,
What do you think?
I'm very concerned. We go back and forth. Kagan will do okay for a little while. He'll then violate probation. I'll issue a violation. He doesn't show up for the hearing. He'll then go on warrant status for a couple months and then he comes back around again. I am very concerned. And again, the last report I have from his mental health treatment's back in August. So I don't know if he's been.
Has he been going?
no, he's been avoiding everything. I sent a message just last week or
He's been what?
I just sent a message to Jessica a couple weeks ago through email because I have the concern that he continues to blow everybody off up under any kind of authority who's trying to put him on the right track.
Hagan, have you ever been to jail?
Yes, sir.
Where?
Marty County, Tennessee.
How long?
I'm still in prison.
Pardon?
Before my dad went to prison.
Yeah, but I'm worried about you right now.
Yeah, it's locked up in Marty County, Tennessee
How long?
for like a week.
Was that a county jail?
Yeah, it was
For?
for theft of Plan B from the broker.
Why aren't you going to mental health treatment?
Just got my services set back up. I have my case
When did
manager.
you last go to mental health treatment?
I think last month. Was it last month? It's been a couple months.
What are you fooling around with cocaine for, son? You can't do this.
He's got.
Well, you can be the leader.
Yes, sir.
I mean, I don't want to make you feel bad, but they're only giving you one of these things called life. And you're not working, you only have a 10th grade education. You're violating left and right. You're not doing what we told you. I mean, I'm surprised. Can I tell you something? The more I look at this file, the only reason I think I gave you another chance because you've blown us off for so long is because I wanted you to do some mental health treatment. I thought that would help. No. Please. No, get the other one that I got like this. Okay. Well, let me see that might be it.
That's all. That's it.
Thank you. I don't think I can do anything here other than send you to jail, and I don't want to send you to jail. What do you think?
I don't know what else we can do for him at this point. I am happy that he's back with his mom. I think that is a good support system, but he'll stay with her for a little bit and then he leaves and she doesn't know where he is for a couple months, couple weeks. So the back and forth, if he stays with her, I think things are a little bit better. She at least tries to hold him a little more accountable, but I don't know if he'll ever stick with that though. He hasn't shown in the past that he has.
Who says he paid all his fines?
I believe it's up $145 still.
We pay that.
Not today, but I've been paying everything.
Judge too, I do want to note, this case is taken under the domestic violence status as well, the special status.
Well, I don't have any choice but to revoke that. 769.4A status revoked. I know I hadn't done that. Conviction entered. I'm going to sentence him anew. I'm going to need a first page of a misdemeanor register. So I'll be right with you, Ms. Tucker. My apologies.
Thank you, Your Honor.
So I'm going to sentence him anew, I guess, and you know, I don't know what else to do with it.
Yeah. You give me one more chance.
I think you told me that, but no.
Clean up, do better. I think we stuff I need to do, we need to run it. I love it.
Listen, I could sit here and never send anybody to jail. It would make my year. But I can't let this go on. I cannot let this go on. All right. All right, so I'm going to sentence him anew. Is there anything else anybody wants to say? So I'm revoking his status, entering the conviction. I'll sentence him now. Does he have any credit for time served coming for court work or community service? Let me see.
24 hours of community service, Your Honor.
Anything else, counsel?
Your Honor, it sounds like he's back home where he does have some direction and some oversight from his mother. I would just ask that be taken into consideration to potentially give him one last opportunity on probation.
There's no way you can pay the $145 today or $200 is what I'm going to ask you.
Thank you.
We're not open Thursday or Friday. Here's what I'm doing. Did I let you finish anything else?
So,
Lisa, please listen carefully. You do such a good job on these, but I want to make sure that this just says, I'll tell you in a second. 100 fines, 100 costs, $200 in 93 days, credit 4. So you're going to serve 89. I will suspend 75 days if the fines and costs are paid. The $200 is paid by Monday. So you're going to only have to serve 14 then. So if the defendant pays fines and costs, we'll suspend 70, not 75. And that's a gift. And I'm going to tell you why I'm doing this, and one reason only. Because I'm still hopeful that you're going to get yourself with your mental health issues soon. You cannot do this. You're ruining your life, and you can do it, but you need to get some help. There's nothing wrong with acknowledging we have a problem and moving forward and trying to correct it, or at least get it under control. But you're not treating, you're doing cocaine. That's what I'm going to do. That's a gift, son. You're in custody. I wish you well.
Thank
You
you.
have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Ma'am, I'm sorry. I really am. Have a good day. Good luck. Priority Waste LLC, 25SO273230 A, B, and C. Okay, so
I'll think about that.
good morning, Ms. Trombley. Your name?
Good morning, Your Honor. Elizabeth Trombley appearing on behalf of Priority Waste.
So you want a bench trial?
Yes, Your Honor.
All right, so you understand, of course, and I have to still cover this with this to appearing on behalf of your client. Your client has to appear, and he understands he has the company understands that they have the right to a jury trial, but knowing all that, they wish to proceed to a bench trial. Is that true?
That's true, Your Honor.
And
Yes.
you're authorized to enter this waiver on their behalf?
Yes, Your Honor.
All right, I'll accept the waiver. We'll set up bench trial. And
Your Honor, could we do at least 30 days? Mohammed indicated that I just will send him an email and he will forward me the discovery or the videos from the officers. So I just want to make sure I have enough time to get those videos.
yeah, if he doesn't, I want to do it before the end of the year because well, I don't have to. I can do it. Lisa, why don't we give him the second week in January? At 1 p.m., I guess it'll be, since Judge Hesson will be on the state docket. Or wait a
That'd
minute. Yeah, this is the state case, right?
Yeah, January 13th at 1 o'clock.
Okay, is that good with you?
Yes, Your Honor. Thank you. I
I
appreciate
just
it.
can't adjourn it again, okay?
I know,
'Cause
yeah.
I'm done with my state docket. Thank you very
Yes,
much. Have a
thank
great Thanksgiving if I don't
Judge.
see you. Oh, I
You
got
too,
another
Judge.
one. What's that, Lisa?
I was just gonna see if you could pull Damaco next because the jail needs their camera. Julian Damaco.
Okay.
Am I all set, Judge?
No, you got one more here, I
Oh,
think.
yeah, I have two, both of them set for bench trial.
All right, let me quickly call this one while she's pulling out that file. Priority Waste LLC 25SO24455 A and B. I'm sorry, I didn't see yet another one. Your name?
Elizabeth Tremblay appearing on behalf of Priority Waste.
We're setting this case for bench trial too, right?
Correct, Your Honor.
Same
We could do
deal,
them on the
you
same
guys?
day if you,
What's that?
we could do them on the same day.
Yeah, but you waive your right to a trial by jury or the company's right to a trial by jury on that case as well?
Yes, Your Honor.
Waivers accepted January 13th at 1 PM, okay?
Perfect. Thank you, Your Honor. Happy
Thank you very
Thanksgiving.
much. You too, thank you. Okay. All right. DeMarco, Julian Angel Ricardo DeMarco, 25B78896. Good morning, sir. Your name?
Julian D'Amato.
All right. Ms. Tucker, your name?
This is Miss Patillo's.
Oh, Ms. Patillo. Ms. Patillo, I need your name, please. So I have something here. The jail's waiting, I'm told. Detective Tulas, good morning. Are you on this case?
Yes, Your Honor.
You're the best at appearing. I'm going to give you a gold star when I see you next. You know that? On the PCCs and everything. All right. Ms. Patillo, can you hear me? Listen, she wants to set it for exam, so we have an exam date. I hate to keep the jail waiting, and she's obviously not in the council room, so I'm going to just go ahead, sir, and set this for December 2nd at 10:30 as it was set before.
Yeah, that's what she said she wanted to do anyways.
Okay, so that's what we'll do. We'll go to the exam next week. Do you have any questions? Talk to your lawyer if you have any questions, okay?
Okay.
Have a good day. Thank you.
Thank you too.
Thanks a lot, Detective. Warren Artherio Slappy Thrash, 25M608585. Did you guys resolve that? Am I going to look at that and have to quarrel with that? If I am,
I think you're gonna be very happy.
good. Good. Do I have anybody here for Slappy Thrash?
Yes, sir.
Yes, he's on Zoom.
Okay. How you doing, Mr. Slappy?
Pretty good. How about yourself?
Not too bad. Your name?
Warren Arterio Slappy Thrash.
Is Trooper Martin here? Thanks, Deputy. Trooper Martin here by chance?
Yes, sir.
Good morning, sir. Your name?
Trooper C. Martin, sir.
All right. Good morning to you and good morning, Mr. Slappy. You're charged with 90 and a 70, 16 to 20 over. Do you care to offer anything here, Trooper?
I can give him 1 to 5 on the freeway if you'd like.
Mr. Slappy, can you listen to me, please?
Yes, sir.
They had you going back in February, 95 and a 70, and you outdid yourself in May by going 103 and a 70. Now, I don't know what you're doing. If you want to be a NASCAR driver, go into it. You can't be driving like a maniac down I-75 all the time. Why are you covering your mouth? You're going to laugh? I mean, I'm not trying to be funny here. I'm just telling you, you're driving like a maniac. Slow down.
I understand, sir.
Well, come on. I mean, come on. You're going to hurt yourself or somebody else. My Lord. I understand it happening. You just keep doing it. So you're good with 75 and a 70, Trooper?
That's up to you, sir. You have the final decision, but I'm good with that.
Well, I try not to get involved in their plea bargaining. What you guys offer or don't offer. Sometimes I'm not as good at that as I should be, but if you're good with it, I will do this. If you're not, just tell me. It's up to you.
Okay, that's good with me, sir.
You want to plead the 75 and a 70, Mr. Slappy Thrash?
Yes, sir.
I'm telling you, you come back in front of me, I'm not going to give you any breaks. Do we understand one another for speeding?
Yes, sir.
To the charge 75 and a 70, responsible or not responsible? Responsible, that's 0 points. It's going to go on your traffic record, but it's 0 points. You understand that?
Yes, sir.
Okay. How do you plead the 75 and a 70, limited access?
Responsible?
I'll accept the plea. Dismiss the original charge. You're going to pay 210 on this. You can pay that today?
Yes, sir.
Mr. Slappy Thrash, I hope you're taking me seriously.
Yes,
Right?
sir. Yes, sir. And I also want to thank the trooper.
Yeah, no, he's an awful nice man.
Yes, sir.
He's doing that. A lot of them wouldn't have done that. Lisa, this commitment doesn't have a signature line. I'm just going to sign at the bottom. They're not going to reject that, right? I wouldn't think. If you think it's a problem, when you see that button, no, okay?
Oh, yeah, I'm
Jason-
sorry. There was a page 2. It's on the printer.
No, that's all right. That's all right. Trooper, okay, you're all set, Mr. Slappy Thrash. Good luck. Make sure you pay that today. Jason Welton Cruz, 25 M612061. Ms. Patillo, I went ahead and just set that for exam. The jail wanted the defendant. It was already set for next week. So I just went on and told them December 2nd. It wasn't your fault. I didn't want to hold them up there, okay?
Mr. Delaco?
Correct.
What's
10:30, right, Lisa?
Thank you, Judge.
I
Thank
believe
you.
so. Yep.
Your name, sir?
Jason Cruz.
Trooper, your name?
Trooper Martin, sir.
All right, now. You gotta quit driving without insurance, son. I can take whatever you're asking me to do here. He's got, it looks like 3 moving violations in the past. If you want me to reduce it, he's charged with 92 and a 70.
No, I can't let above 90 is pretty fast on the freeway there, sir.
Well, the other guy was going 92. I'm not, if you don't
Yeah,
want to
and-
do, pardon?
Did he have no insurance as well, correct?
No, this was just, I'm just saying he didn't have insurance on 3 other dates. He had, maybe he's only got 2 moving violations. He had no proof of insurance a couple of times in 24 and 21 and 20. But this one was not cited for no insurance.
Sir, is this Christopher Metzger James? I'm
This
not
is
sure. if this is
Jason
correct.
Welton Cruz. Jason Welton Cruz.
I'm not sure if I have that one, sir.
He's got a 2020 improper lane use, and besides the no proof of insurance, he's got a default judgment on a careless driving from 24 in the state of Kentucky. And other than that, just pretty much no proof of insurance. So I'm okay if you reduce it.
Okay.
If you want to.
All right. Yes, sir. I'm saying I'm not sure if this is my person. The other spin I have here is for Christopher James Metzger. Was I the OIC on this ticket?
You were on this one.
Okay. All right. This one I can do 1 to 5. I'll do the same thing as well
You
as the
want to plead
previous
the
one.
75 and a 70?
Yes, sir.
You gonna slow down?
Yes, sir.
Slow down. To the charge, you guys got to thank this guy. He's a nice man. To the charge, 75 and a 70, responsible or not responsible? Okay, I'll accept the plea.
Sorry.
Go ahead.
I just say sorry to the officer and you, Judge.
You don't have to worry about me. I wasn't driving 100 miles an hour to catch up to you.
Yeah.
You don't have to say anything to me. You apologized. You're good. You're good. You're a nice young man. I'll accept the plea. Is that what you want me to do to 75 and a 70? Responsible? I'll accept the plea. 170. I got to go a little higher. 180. Okay. 180. Please slow down. Okay. Good luck. Where do you work?
Corp Energy, I do underground utility.
Yeah. So you're working hard to make that money, right?
Yes, sir. I pulled over on Sweetest Day.
Sweetest Day.
Yes, sir. I was running a little late to the wife and
you know.
You had flowers and candy and
Yeah, and I was taking her out to a nice dinner and, you know,
plus the flowers and candy and all that, huh?
yeah, so.
This new generation, I love that. That's great. I mean, young generation, I should say.
So that, I mean, you know, obviously no reasonable explanation, but.
You're good. You're good. Just slow down, okay? All right, have a good day. Enjoy your Thanksgiving. Christopher James Metzger, 25M614664. All right, Mr. Metzger, good morning. Your name, sir?
Christopher Metzger.
Good morning, Mr. Metzger. Trooper, your name?
Trooper Martin.
Okay, so we got an improper lane use. He's got quite a record here, it looks like. Have you looked at it?
No, sir, I haven't had a chance today.
I mean, hazardous action, unable to stop assured clear distance back in 19. He had disregard traffic control device, hazardous action in 20. He has prohibited turn from January of 25. Another hazardous action, unable to stop assured clear distance in 25. It's improper lane use. If you can figure out a 1-point violation, I'd be fine with that. He was on I-75 if you want to do, or a 0 point even. If you want to do 75 and a 70, it's up to you though.
I can't really change from a lane violation to a speeding violation per my policy, or I would, sir. Sorry. So I can't think of anything else. I'll leave that up to you, but I know I can't change from, if I write him for a lane violation, I can't change it to like a speeding infraction, if that makes sense.
Yeah, I can't really think of anything else. Boy, you got to be careful. You've had 3 tickets in about 6 months.
I'm aware of that. I can't defend the failure to stop. That was just an accident. The turning on the red light, I was stopped at a red light. It was 1 in the morning. A cop flew up behind me. I assumed he wanted to turn, so I turned on Eureka Road to get out of his way, and then he turned and pulled me over right away and said, "You can't turn." Well, I told him I assumed that you were trying to get by me in a hurry, so I just was getting out of your way. He gave me the breathalyzer, made me do all the walking the line, stuff like that. I obviously was not
4 o'clock in
intoxicated.
the afternoon.
On January 17th.
No, October 27th. We're talking about your ticket.
Oh no, I'm sorry. No, I'm sorry. I was talking about one of the tickets, the failure to turn. No, this one right here. I drive 70 miles a day. I'm a teacher. I live in Flat Rock. I teach in Grosse Pointe. I drive a long ways. My dog was going through some stuff for about 2 weeks on that day. Specifically, my dog had to go into the emergency vet. She wasn't moving. I was kind of sad.
Problem. I mean, no disrespect. You really don't qualify. If he wants, I can't, well, it is more than 5 years. If you want to do something else, is there something else we can do? I mean,
I was hoping, I can pay the ticket. I was just hoping for
please stop a second. Okay. I know what you were hoping, but you got to drive better. Come on.
I know.
I mean, I don't mind if you do impeding, if you feel comfortable with that, Trooper. If you don't, you don't.
Yeah, yes, sir. I can do impeding. I think that falls under the same rule there. Just, I can't change a lane use to a speeding infraction.
I got it. You want to plead the impeding?
Yes, please.
Mr. Metzger, stop, please. Okay. I'm serious. To the charge impeding traffic, responsible or not responsible? Responsible or not responsible?
Responsible, yeah, sorry. Responsible.
Accept the plea. Now listen, you're just outside the 5-year zone on the first one. That's the only reason I'm doing this. 195. You can pay that today?
Yes.
All right, you're all set. Have a nice Thanksgiving. Thank you. People against Moran, Carrie Ruth Moran. Is Carrie Ruth Moran here?
Attorney Corey Westmoreland appearing on behalf of Miss Moran.
This is file 16W810025-15W806-545. Do you have another
He's on
one,
Zoom.
Trooper?
No, sir, I'm all set. Thank you. Have a good Thanksgiving, sir.
Thanks a lot. You too. Carrie Moran is not here. You haven't talked to her?
She's on
She's
Zoom,
on
Judge.
Zoom, Your Honor.
I just can't get her to connect her video.
She lives in Riverview, right?
She told me that she was disabled, so she couldn't drive here.
Your name, ma'am? You have to unmute in the bottom left-hand corner of your screen, please.
Okay,
There you go.
What is your name?
Carrie Moran.
All right, counsel. I want to be sympathetic, and I am sympathetic. I don't know what the nature of the disability is. I don't really need to hear it. But this money, and I mean, she's owed this money on this civil infraction charge for 10 years. And then she failed to appear for a pretrial. What are you doing, Ms. Moran? Why weren't you here? Why aren't you showing up on this case?
Well, I can't show up in the courtroom. I'm bedridden. It just, I was in a nursing home for a long time. I don't mean to go on, but I had,
Ma'am.
yeah,
I still have to proceed with these cases.
I know.
Now,
I know.
I don't think you do because you haven't been here for 9 years on one and 10 on the other. Now, I don't particularly relish putting people in jail, but I'm telling you, you are really close at this point. I mean, what are we doing? This is a retail fraud from December 1 of 16 that you didn't show up on, that I was nice enough to give you a personal bond on 3 weeks ago. And now here you are, I've arraigned you. I've dismissed show causes. I've told you to pay 50. I mean, we have gone round and round and round. You're not going to really force my hand, are you?
I really want to settle this.
Well, listen, there's no settling anything. I don't know what you mean. You can't look a judge in the eye and tell him you want to settle something that's 10 years old. I mean, come on. How can you tell me that? How can you look me in the eye and say that? I'm trying to be understanding here, but where'd she go? Ms. Moran.
I'm here.
Do you have
I'm
family,
sorry.
ma'am? Do you have family?
I have 2 sons. My
Well, have you-
husband is.
Have you told your sons
family
about this issue? Maybe you need to talk to your sons about this.
My sons know about it.
Well, maybe they can come up with the money to help you because my patience at this point is running thin. Okay, I can't blame you.
Please, Judge, understand. I had a trach in my throat for a long time.
What do you want me to do, Ms. Moran? Tell me what you want me to do.
I want to settle. I want to settle this.
Can you get out of the house and do some community service? I'll be glad to let you do that.
No, Judge, I'm bedridden. After I had gone into septic shock, I came down with this Guillain-Barré syndrome that I'd never heard of, and it paralyzed me. And I had to have a tracheotomy.
All right. Okay. All right.
I truly am sorry.
All right. Okay. Let me think. Can you send me some doctor's proof of this condition?
I've been collecting it like you asked me to.
Well, why don't you send me what you have at this point? I got to end this case at some time before I leave the bench. You know what I'm saying?
Yeah.
I mean, come on. Lisa, give me a date when Woodhaven's here again. Now, reschedule with Woodhaven, pre-trial. Are you? Go ahead.
December 10th at 11.
Maybe, you won't be representing her. Mr. Westmoreland won't be representing her, will he?
No,
No, Your
Mr.
Honor.
Crawford will be here that day.
Okay, I do.
Ma'am,
I do.
Ma'am, you have what? Go ahead.
I just want to let you know I have a kidney operation on December 8th.
we can't go, Woodhaven's not here next week, Lisa?
They are, but for Judge Hessen.
Yeah, okay.
And then you don't.
I don't
have a
even
Woodhaven
mind
until
dismiss this
January.
if that's what they choose to do. I mean, I don't even know, but they can't dismiss it if she doesn't show up. Why don't you give me another date there, Lisa? Like what? I don't want to go to the 24th. Do I have anything on the 7th? That's Judge Heston's too, right? On the 17th?
Can we go to January?
I don't care. That's fine.
January
Let's do it.
7th,
January 7th
8:30.
at 8:30. Now, ma'am, here's what I'm going to do. If you said you have your kidney operation on December 8th, right?
Right.
So maybe we can figure out a way where he might be willing to dismiss this. Why don't you tell him he should, you run into Mr. Crawford, don't you, Mr. Westmoreland?
Occasionally.
I mean, well, I'm going to put this in highlighting, hope somebody sees it. I don't see the point in going on with this criminal case for sure. She can't do community service, what she tells me is correct. I don't know why I wouldn't just purge the contempt and let her go. You have to provide proof of medical condition though, okay, ma'am? Give me what you have. You can have your sons make copies and send it up here. I don't want your originals, okay? Now,
right.
But you have to show up on January the 7th at 8:30 in the morning. So I'll schedule both these for that, Lisa, okay?
Okay.
You know,
I mean, I'm in a hospital bed right now. I can show you.
yeah, I get it. I didn't know that. I'm sorry about that.
And I'm sorry about.
Don't worry
not
about
resolving
anything,
this.
okay? I want you to worry about getting yourself better and having a nice Thanksgiving. You see, Miss.
I'll
I
talk
just
to
don't-
Mr. Crawford about it, Judge.
Thank you very much. Ma'am, I wish you well. I'm going to try to help you here. Okay? Send me
wish
what
you
you
well,
can.
too.
Send me what you can. At some point, it just seems to me it's silly to proceed on that, but that's not my call. Thanks.
Yeah. Thank
Good luck.
you.
You're welcome.
Thank you.
This is Herlin Antonio Melgar Rodriguez, 25M 608632. Come on up here. Did we get a Spanish interpreter for today, Lisa?
What was the name on this one?
Herlin Antonio Melgar Rodriguez. It's 25M 608632. I wrote down on the 4 Spanish interpreter. I think this is the one I sent down there. You were going to have him listen to something so he could at least understand his court date.
Let me check. I do not have anything in the system.
Okay, well, I don't know if you were here or not that day. Call in Mr. Mohammed, please. Okay, just bear with me. I know you don't. Okay, we're going to get a Spanish interpreter. Spanish interpreter, and we'll reset the arraignment and pretrial, okay? So, Lisa, why don't you give me a date for that? And I'm going to talk to Mr. Mohammed first, though, because they've written a citation for operating without a security. And that's a misdemeanor they've cited it as. And they can charge that with a complaint and warrant, but not a citation. And I want to point that out. Your name,
Good morning, Your Honor. Mohammed, I'm happy to.
He doesn't understand anything. We were supposed to have a Spanish interpreter and we don't have one. So he doesn't understand. But the trooper issued a citation, misdemeanor, having insurance without, operating without security. That's a 1-year misdemeanor. They can't issue a citation on a 1 year. They have to go under state law and get a complaint warrant then if they're going to do that, right? That's what they have to do. So I'm just saying that I might have pointed this out before or just thought about it, but I don't know. We're going to have to get an interpreter. So I'm just giving you a heads up that this either needs a complaint and warrant or something else. Lisa, John, walk him down, please, so he goes down there. I don't think he went down, or I could be wrong about that, Lisa. So check with, maybe you can play that for him and make him understand what day we're going to do. And that will be on what day?
December 9th at 9:30.
Okay, December the 9th at 9:30, sir, okay? He can't understand me. Sorry. So walk him down and they'll play that for him. Thank you, Mr. Mohammed. Tiffany Monet Brown, 25M7168822. Do we know for fact, Ms. Davis, that she's in labor?
She has 3 weeks until she's due.
Like, she's in labor then?
She's not in labor today. She was on Zoom.
Oh, I'm sorry. This is 25M7168822. Tiffany Monet Brown. Your name?
Tiffany Monet Brown.
Well,
May it please the Honorable Court, John Tucker Davis, P59229, representing Miss Tiffany Brown.
she's going in labor in 3 weeks?
Yes. Could be any time.
Well, we'll just go to the exam then, right?
Well,
Next week? They set it for December 2nd at 11. I got to get rid of these cases before the end of the year. I don't want to, if I adjourn 2 weeks, she's likely to be in labor, or then, I can't put it out that far. I don't have a problem with proceeding with the exam next week.
do we have an 11 o'clock open?
That's what it is. It's 11 o'clock. Okay. So we'll proceed to exam next week. Ma'am, you have to be here in person next week, December 2nd at 11. Do you understand that?
Correct.
All right, we'll proceed to the exam then, okay?
Okay, thank you so much.
Have a great day. Thank you.
Bye-bye.
Do you have another one, Ms. Tucker?
I do. I have an exam at 10 o'clock.
Okay, but you don't have another case in front of me over here? All right, thanks. Okay, this is going to suffice. Where is Ms. Dunn? Where is Ms. Dunn? And I need her lawyer in here. Oh, okay. So I'll pass that when I'm told he's on a Zoom call, Lisa. Dakota Allen Stoll, 25G7275331. How you doing today, Ms. Patillo?
Good, Judge. How are you?
Pretty good. Thank you.
Thanksgiving.
Me?
You understand that you paid some money.
I don't think you'd want to eat, anybody would want to eat my cooking unless it's. Okay. So I have Dakota Stoll. Where is Mr. Carmen?
Your Honor, I'm retained on the matter.
Do I have an appearance from you?
I did
I just
email
got it,
to you,
Judge.
Okay, good enough. So we're going to go, your appearance?
Good morning, Your Honor. May it please this Honorable Court, David Burgess on behalf of Dakota Stoll.
So we're going to proceed to exam December 2nd, and that will be at 10:45, right?
That's correct, Your Honor.
Okay, we'll see you here then. Where's your client at, Dakota Stoll?
He was on Zoom, Your Honor. I thought he was still there.
Oh, Dakota Stoll, you have to start your video, please. Start your video. There you go. Your name, sir?
Dakota Stoll.
All right, so we're going to go ahead and proceed to the preliminary exam. That will be next Tuesday, December 2nd at 10:45. And that will, of course, be in person. Do you have any questions, Mr. Stoll?
No, Your Honor.
All right, we'll see you then, Mr. Burgess. Thank you.
Thank you, Your Honor.
Johnny Lou Hensley. 25W716781.
Good morning, Judge. The app is TOP 82378 on behalf of Mr. Von Hensley, Session.
Got it. What are we doing on this?
So, Your Honor, I did have a chance to talk to the prosecutor. Mr. Von Hensley is going to plead as charged under 771.1.
It's assault or assault and battery. If he has, does he have, my gosh, Mr. Hensley, he show up? If he has any assaulted crime on here, I'm not going to take that. I want you to be aware. Okay? Does he have any? In assault or assault and battery dismissed, not once but twice. Okay. Is that what you want to do, Mr. Hensley? What's your name, ma'am?
That's Shalonda, high-speed interpreter, Your Honor.
Oh, you're
I
the
saw someone in the hallway, and I'm here today for another case. Would you like to handle him today? Is what I would.
Speak Spanish?
Yes.
Perfect. Lisa, if he hasn't left, we could.
Yes, he's at the, I told him to wait for me.
Beautiful. Thank you. Thank you. Great. Okay. You understand what your lawyer has said? Okay. I'm sorry?
Yes, sir.
So she's telling me you were going to plead as charged to assault or assault and battery. If you do that, I will take this under section 771.1. It is punishable by up to 500 fines, 93 days jail, costs, or all those. Do you understand that? Do you understand that?
Yes.
And I'll take it under section 771. If it's implying at the end of the specified term that I set, the case will be dismissed. Do you understand that?
Yes, sir.
Did you sign the advice of rights?
Yeah.
Did you read and understand the rights?
Yeah.
Will you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial of any kind. Do you understand that?
Yeah.
So he's going to plead on both?
Yes, Your Honor.
So he's going to plead to both trespass and assault or assault and battery, right?
Good morning, Your Honor.
Good morning. This is case. Let's go off the record. You okay? You good? Good. Okay. All right. All right. This is case number 25CR43159, the State of Ohio versus Charles Henson. Mr. Henson is before the court with his counsel, Ms. Smith.
Yes, Your Honor, thank you.
Ms. Tranter on behalf of the State of Ohio. Ms. Tranter.
Your Honor, my understanding, this morning we have filed a bill of information on a felony 5 theft. My understanding is that Mr. Henson is prepared to enter a guilty plea to that bill of information this morning.
Ms. Smith, is that accurate?
Yes, Your Honor.
All right, Mr. Henson, there's a number of things that are going on here today, so we're going to kind of cover them one at a time. And there are some things that I am required to do before we ever get to your change of plea, okay?
Yes, sir.
All right, first off, is they're telling me that you're going to be entering a plea of guilty to a bill of information as opposed to an indictment. Do you understand what the difference is?
I do in a sort, sir.
Okay, well, the Constitution provides that you cannot stand trial for a felony charge unless your case is first considered and heard by a grand jury, okay? The grand jury, they hear at least some of the evidence in the case, and they make a determination as to whether there is probable cause that a felony was committed and that you were the person that committed it. So the threshold for a grand jury is probable cause, okay? You understand that?
Yes, sir.
All right, so the first thing I have here, the state has filed the bill of information charging you with 1 count of theft, a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison term is not mandatory. Do you understand that?
Yes, sir.
So that's the bill of information. You are also, and I have here a document called a waiver of 1 day service. And basically what that means is when you have a charging document, whether it's a bill of information or an indictment, you have the right to wait at least 24 hours before you are asked or required to enter a plea, whether it's guilty or not guilty. And you've signed this document with your attorney. She's explained that to you, and you wish to waive that 24-hour rule, correct? All right, very good. And then finally, you've signed, and we talked about the bill of information versus an indictment. That's your signature on this document called waiver of indictment.
Yes, sir.
And you understand that that is a constitutional right that you are giving up.
Yes, sir.
And this is how you wish to proceed. All right. So I also have here another document that's called a change of plea, although you're not really changing your plea because you haven't entered a plea yet. But we're just going to proceed as if there's currently a not guilty plea, and we're just going to go through the requirements. I've already read to you the offense that you'll be entering a plea to, the mandatory penalties involved with that. Do you understand those maximum penalties? Mandatory. I said mandatory, but I meant maximum.
Yes, sir.
All right. How old are you?
64.
How far did you go in school?
I graduated.
So you can read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir, I am.
Has anyone promised you how the court would sentence you in this case?
No, they haven't.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation of Ms. Smith, Mr. Mulligan in this case?
I am, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
All right, I have this document. We've talked about the maximum penalty. Is that your signature?
Yes, sir. it is.
And you read this and you believe you understand what it says?
Yes, sir.
And you went over it with Ms. Smith?
Yes, sir, I am.
Okay. In addition to those maximum penalties, excuse me, sir, you are also subject to a discretionary period of post-release control, which means that if you are sent to prison on this charge, when you are released, the adult parole authority may supervise you for up to 2 years.
Yes,
If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. And that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But as I said, it's not mandatory that you're sent to prison at all. The court does have the discretion to place you into community control, or what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir. I do.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt. Where the jury is required to find you not guilty, their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, you have the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir. I do.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of the charge from the, in this case, the bill of information. Do you understand that?
Yes, sir.
Do you believe you understand each of those rights we've discussed?
Yes, sir, I do.
And you understand that when you enter a plea of guilty, you'll be waiving all those rights. We will not have a trial.
Yes, sir.
There is one other thing that I didn't mention, is that you could waive all your rights that we've discussed. Strike that. You could waive your right to trial by jury and try your case to the court. I too would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that? This is how you want to proceed this morning.
Yes, sir.
All right, Ms. Tranter, statement of facts, please.
Your Honor, this occurred November the 3rd, 2025 in Warren County, state of Ohio. Mr. Henson did with purpose to deprive the owner of property, exert control over that property without consent. This involved some construction equipment, a couple of, looks like welders and welding cables. Value of the property was over $1,000, but less than $7,500.
Ms. Smith, anything on those facts?
No, Your Honor.
Mr. Hanson, did you hear the statement that she read?
Yes, sir, I did.
Do you admit and acknowledge that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed?
Yes, sir.
And what is your plea?
Guilty.
All right, the court's going to make a finding that you've made a knowing, intelligent, and voluntary waiver of your, of the indictment and of your constitutional rights. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I am going to order a pre-sentence investigation, Mr. Henson. I don't know enough about you or about this case to sentence you at this time, so we'll come back in a few weeks and do sentencing at that time. Ms. Smith has indicated that she's going to file a request to modify your bond, which I will hear after proper notice is given to the victim in the case. Ms. Tranter, is there anything else?
No, sir, thank you.
Ms. Smith?
No, Your Honor, thank
All
you.
right, I'll see you in a few weeks. Thank you, sir. What's that?
Yes?
Yes.
And if you plead on the trespass, it's punishable by up to 30 days jail, fines $250, costs are all those. Do you understand that?
I will be aware of that.
Yes.
Yes.
Mr. Hensley, hang on. Just slow down.
Okay.
Okay? You don't have to do this if you don't want. We can go to trial. We got one set for next week. I don't have a problem. If you plead with the assault or assault and battery, the possible penalties are up to 500 and fines, 93 days jail, costs are all those. If you plead on the trespass, that's punishable by up to 250 fines, 30 days jail, costs are all those. I'll take both of those under 771.1. That was the offer, right?
That was the offer, Your Honor.
You understand that?
Just the probation. Yes, sir.
I don't know what you mean by that, sir. There's no, I don't know what you mean. I don't know what you mean by that. You understand what the possible penalties are? I have to tell you the possible penalties. If you don't want to plead guilty, you don't have to plead guilty. It seems like it's a fair deal to me, but I don't know. And you don't have to do it. If you don't want to do it, don't think you're guilty of either one of those, that's fine. We'll go to trial. I could care. Doesn't matter.
I plead.
But let's go one step at a time. Do you understand everything that I have said here today? Mr. Hensley, I'm going to put you at the back of the call here real quick, okay? I'm not going to play games with you.
Yes.
If you're not understanding something, tell me. If you understand it, tell me. If you don't, tell me, but I'm not going to go through this little cat and mouse where you want me to.
Understand. So,
Okay. Did you sign the advice of rights?
yes, I
Did you
do.
read it and understand it?
Yes.
If you plead guilty, you're giving up all those rights, and there will not be a trial. Do you understand that?
Yes.
If you plead guilty to these, I'm going to place you on probation for sure. I don't know what other penalties there will be, but you will be on probation because it's under 771.1, and you'll have the opportunity to keep both of these off your record if you comply with probation. Do you understand me?
Yes.
All right. Any questions before we go?
No, sir.
To the charge of assault or assault and battery, how do you plead?
Possible.
Guilty.
Guilty.
To the charge trespass, how do you plead?
Guilty.
Were you at Guardian Car Care on July 16, 25 at 18720 West Road in the city of Woodhaven?
Yes, sir.
Did you go on the property of Guardian Car Care?
Yes.
And had you been forbidden to do so by the owner, Michael Powers, prior to going on there? on July 16 to 25? He tell you couldn't go there before you went?
I wasn't aware of that. He never told me that. But, okay, if he did, he did.
I don't know if he did. I wasn't there.
I wasn't aware of it, but if he said it, he said it.
I can tell. I should just set this for trial, shouldn't I? Because he doesn't want to plead. That's fine. Sir.
I was there.
Sir.
Yes, sir.
I got a bunch of people wait. I don't like the people wait. I'm going to go slow enough to do what I need to do, but I'm not going to go back and forth with you. If you don't think you did anything wrong, by all means, go to trial. This is the United States of America. But don't say, I don't know. If he says I did, I did. He did, he did. And if he didn't, he didn't. And I don't remember him telling me. And that's okay. If that's the truth, we'll just go to trial. That's fine. Is that what you want to do?
No, sir.
I'm going to ask you direct questions now. And I want a direct response now. Did this gentleman, the owner of Guardian Cart Care, prior to the offense date of July 16, 25, tell you were not to go back to Guardian Cart Care at 18720 West Road, New Haven? Yes or no?
Yes.
Are you sure?
I'm sure. I'm pretty sure. Yes. Okay, he did. I'm sorry.
Are you trying to agitate me?
No, sir. No, sir. I'm nervous.
Nervous? I'm nervous.
I've got.
What are you nervous about? There's nothing to be nervous about. You either want to plead or you don't want to plead. We've been going back and forth. This case was arraigned back in July. This has got to be one of the longest cases on my docket where people actually showed up, although you did have a miss or two, a couple of them.
I'm sorry, man.
Just tell me, did he, if you don't know that he trespassed you from the property prior to the offense date, just tell me that. Did he trespass you, tell you not to go on the Guardian Car Care property prior to July 16 of 25, which is the date of this offense?
He may have told me I don't remember.
Okay, well then I just can't take the plea. I'm sorry. We'll go ahead with trial next week.
Okay.
And, I just.
Yeah, I'm sorry. He did tell him that.
You think I want to play this game with you?
No, sir.
Do you think I look like, look at me. I don't have time for games. I don't have time for games. I'll give you all the time you need to be heard, but don't play games with me, please. You don't have to do anything today. You can say, Judge, I want to go to trial. That's fine. If that's what you want to do. But when I tell you repeatedly, I'm going to ask you a question and I want a straight answer and you're vacillating, I don't know if that's what he said. Maybe I did. Maybe he didn't. I don't remember. And now you're saying no. And then you're saying yes. And I don't know what to think. You got my head spinning over here. I'm going to ask you one more time. And again, if he didn't tell you that before that, just tell me that. It's fine. Did he trespass you from that property prior to July 16, 25, when they think that you entered the property?
I did not hear Michael Powell's mouth. Tell him.
Good enough. Good enough. We're going to set it. We're going to go to the bench trial. Will remain bench trial at 1 p.m. next Tuesday, okay? And you can go down the hall and get your new date, and you're all set, and I wish you well. Good luck. Not your new date, your old date. Paris, Arsland, 25 W727583. Mr. Batar? Mr. Batar, is he out there? At least I saw him earlier. I don't know if.
Yeah, he's on Zoom.
All right, Mr. Batar, good morning. Your appearance?
Good morning, Your Honor. Which case are we on, Bruce or Arslan?
Paris Arslan. I don't know, is he with you?
Daniel Bater on behalf of Mr. Arslan, Your Honor. I just got off the phone with him. He's been waiting for an hour. So he's been on.
He's
been
not on.
Zoom?
He was on, but he's not on right now.
He might have went to plug in his phone, Judge.
Well, that's fine, but the case was scheduled for 9:30. I mean, I'd get through these as quick as I can, but you know.
I'm not blaming you, Judge. Don't take it that way, please.
Okay, well, we'll wait for him. What other one do you have?
Janelle Bruce.
Janelle Nicole Bruce, 25R724410.
Daniel Bater on behalf of Janelle Bruce, Your Honor.
It's Janelle Bruce here. Come on here, ma'am.
I'm sorry. I had to start my audio.
Your name?
Janelle Bruce.
All right. You want to withdraw, it says. Has there been a breakdown in the attorney-client relationship? Can you give me just a brief little summation here?
Judge, there's really not much I can say. There has been a breakdown in the, ma'am, please. There has been a breakdown in the attorney-client relationship, Judge. I don't want to get into any specifics because I don't want anything to be held against my client, but yeah, she needs a new lawyer.
I get it. Ma'am?
Yes, sir.
Any objection?
Not one for me, Your Honor.
So what I want you to understand, I don't know what your level of education is, but you know, these people, they go through a lot of schooling, and Mr. Batar is a good lawyer. Okay. He's been in front of me enough where I feel very comfortable telling you that. Sometimes we think we know more than lawyers. I don't know why that happens with lawyers. None of us think we know more than our doctors, but for some reason, a lot of people think that lawyers don't know what they're doing, and I don't get, not a lot, but a fair amount. So I'm going to let you out. I'm going to let them out. I'm going to give you a new lawyer, but we're not going to play this game, okay? So motion to withdraw is granted.
Thank you, Judge.
I'm going to go ahead and I'm going to adjourn PCC, Lisa. This has kind of been, not too long. Can we just do a week? Can you get somebody in a week, do you think?
If I can.
All right. If you want me to go another week, I don't have a problem. I was going to go PCC.
No, I can do it. I can do it in a week.
Okay, so we're going to do it in a week, and then we'll do it at 9:30. Do you have a form order allowing withdrawal of counsel you can send me, please, Mr. Batar? I think I probably should have that. Or do we have?
Judge, there's probably something I can draft an email to the court.
I mean, it doesn't have to be long. Do we have something I can write up, Lisa?
Well, he was appointed, so I don't think we really need it when he's appointed.
Good enough. December 9th will be the exam, and that will be at 10:45. So 9:30 on the PCC. Ms. Bruce, you got to come back here, please. And
I'm sorry.
December 9th at 10:45 on the exam. Okay, thank you. Thanks.
Thank you.
We'll see if Mr. Arslan's out there. If he is, I'll get you out of here, okay?
Thank you, Judge.
It's not on Zoom.
Do you think you can call him and ask him to reappear on here for me? And we'll go.
I will right now, Judge.
Okay. Herlin Antonio Melgar Rodriguez. 25M608632. Where'd the interpreter go?
Court law.
Moisey Simon Bijan, 25M610835. Do we have Mijan in here? Ikaban?
Yeah, there's an attorney. I'm bringing him in right now.
Yeah, thank you. Good morning, Mr. Ikaban. When you come in.
Good morning.
Good morning. This is 25M610835. Your appearance?
Radu Yakuban P72819 on behalf of defendant Mr. Bejan.
Okay, so you're authorized under this plea. It's going to be a plea of 6 to 10 over with the careless driving to be dismissed. True?
That is correct, Your Honor.
All right. And you're authorized under that plea. True?
That is correct, Your
To
Honor.
the charge 6 to 10 over, responsible or not responsible?
Responsible.
I'll accept the plea. 175, dismiss the careless, December 5th he has to pay on. I'm sorry, December
December 5th.
2nd he has to pay by, okay? December 2nd.
December
175. Okay? Have a good
Thank you, Your Honor.
Thanksgiving. Thank you.
Thank you. Happy Thanksgiving.
Mr. Zelnick, what case do you have, sir?
Mr. Maldonado, it's a civil infraction. Enjoying the morning, little father.
Yeah. You better than me, I hope. Keith Edward Maldonado, 25M6086-433.
Maldonado.
And then bring Mr. Cayley in here on his URS Midwest. Keith Edward Maldonado, 25M606433. All right, Mr. Zelnick.
Mr. Zelenak, on behalf of the respondent, I have authority to enter into the plea.
6 to 10 over.
Yes, you brought.
Limited access. And then the, what was it? 102 and a 70 to be dismissed, right?
Some car he had, yes.
Driving a little fast. To that charge of 6 to 10 over, responsible or not responsible on his behalf?
I will plead responsible. There's no doubt that he was doing the actual speed cited by the troopers. Never make mistakes, Your Honor.
I'll accept the plea. 185, pay by December 2nd. The original charge dismissed.
Thank you for your indulgence, Your Honor.
Have a nice Thanksgiving. Thank you. URS Midwest Inc. Sorry, Mr. Cayley, 25S118262. Your appearance?
Morning, Your Honor. Roger Cayley, P4811, on behalf of URS Midwest.
Is this overweight reduced to 700?
It is, Judge.
All right, I just couldn't read his writing. It looked like it, though. So you're going to plead to that? You're authorized to enter that plea, correct,
Yes,
on behalf of the company?
Plead responsible, Judge.
All right, please accept it. $700 paid by, I'll
I get a
just
little
give
more
until
time, Judge?
December 27th. What's that?
Perfect. That's fine, Judge. That's what I was
Have
going to
a
ask.
good day. Enjoy your Thanksgiving. Thank you.
You too. Yeah, happy Thanksgiving, Judge. Thank you so much.
Thanks a lot. Where
Thank
is
you.
Mr. Arslan? Ferris Arslan. You have to take your hat off if you would, please, sir. 25W7275583. Mr. Arslan, take your hat off, please. Your name? Is he
On
there?
behalf of Mr. Arslan, Your Honor.
He's just frozen.
Judge, we're just setting this for an exam.
I know.
He's gonna.
I know. Lisa, chat with him. You're going to talk to him, right, Mr. Bitar?
Yes, Judge. Well,
So we have it already scheduled for 10:45 next Tuesday. We'll keep it at that. If you could notify him, please. Okay?
I will let him know, Judge. Thank you. Happy Thanksgiving to you and your
Same
staff.
to you. Thank you. Christina Williams. Christina Williams, 25M7168821. As soon as Westmoreland's ready, I will take that. I want to get the interpreter out of here. If he's on with no, he wasn't on with the interpreter, was he?
He grabbed them and pulled them out.
Do I have Christian Williams out there? You have to start your video, sir.
Yes, I'm here.
Your name?
Good morning.
Christian Williams.
All right.
TOP 82378 on behalf of Mr. Williams.
This is going to exam two.
This one should be set for another PCC, Judge. I was just appointed today.
Okay. Sir, you have the right to a probable cause conference within 14 days of the date of the arraignment. That's today. Your lawyer needs an adjournment. She was just appointed. She needs to review all the discovery materials. So if she's asking for an adjournment for discovery, now that I look at this more closely, I'm willing to do that. Do you wish to waive your right to have the probable cause conference within 14 days of the date of the arraignment?
Yes.
Anybody force you to do that?
No.
All right, we're going to do, I'll adjourn the probable cause conference to December the 2nd. Lisa, what time?
5.
I'm sorry, you kind of cut out there.
Sorry, 9:45.
Mr. Arslan's now smoking a cigarette with the hat on. Love it. All right, December 2nd at 9:45, December 9th. What day are we doing the exam, Lisa?
Judge, I'm House Counsel on December 9th in 34th District.
You're not gonna, we can do it the 16th though, right? I can't adjourn it past that.
Yeah, I do it the 16th.
I'll do it the 16th for you. At what time, Lisa?
10:30.
At 10:30. Okay, no problem. So you understand you can appear by Zoom again next week. That's December 2nd. And then if it goes to an exam, a preliminary exam, that's going to be December 16th. So next week, next Tuesday, 9:45, and then the 16th at 10:30. Okay?
Okay, but my fiance Tiffany Brown, I don't know when she is going to labor, so that's why I was.
I'll worry about that when it comes to it.
Okay.
Okay?
All right.
Good luck. Good luck with that. Boy or girl, or you don't want to say, or you don't know. You don't have to say anything. I just was curious.
Oh, it's a girl.
Well, congratulations to you.
Thank you.
In case you haven't figured it out yet, girls are a lot easier than boys, but that's neither here nor there. Good luck.
Yeah, I got this is my second girl. I got one that's 4.
Well, good for you. Congratulations. Enjoy your Thanksgiving. We'll see you here next week. Okay.
Okay.
Well, what's that?
Say same you said next week, Judge. Oh, my apologies for the PCC. I'm sorry.
I misspeak enough without.
I'm sorry, Judge.
It's fine. Okay. I'm going to go on to Lawler here.
Judge, I was just appointed to that one.
Jeez. Marcellus Cortez
Judge.
Lawler. Yeah.
There was a special prosecutor, but she had to leave for another hearing.
They're killing me. You know that? Okay, that's fine. Is she not coming back? I mean, what am I supposed to do?
She said she would try. I had to get a spot appointment because Mr. Lee withdrew.
Yeah,
So
right.
they hadn't assigned it yet, so I had to call and get a spot appointment.
No, I understand. The question that I have is, she's a special prosecutor. I got a set of time with her. I want to make sure that these dates are good. I mean, so is she coming back? Do you know? Can you text?
Her message to me was that she would log back in.
Okay.
As she was available.
Okay. Well, I'm sorry. Well, I'm going to have to keep you on that one. You're here today for a while anyway, aren't you?
Yes, I have an exam at 2 o'clock.
That's right. Okay. Joshua James Kolidzaki? Adjourned for respondent to provide proof of full compliance of law. What does that mean? Where'd he go? Do we know, John, or no? You don't.
He was on Zoom. I had him in a breakout room with Mohammed, but I don't see him anymore.
Adjourned to December 2nd. Is that good, Lisa, or you want me to do the 9th?
No, that's fine. The 2nd.
And we'll make it at 9:15 again. How's that?
Okay.
Okay. Andrea Renee Young, 25M615082. Ms. Young, come on up, please, if you're here.
She's in a breakout room. Let me move her.
The officer's not here, though, it says. Trooper Milbacher, I don't think.
No, he's not here.
All right, just bring her in and I'll tell her today's her lucky day.
It's not letting me move her. I got to close the rooms.
Okay, take your time. What do you need, Mr. Gregg? Do you have one?
Judge, I'm just seeking an adjournment for Mr. Rydell.
Okay, well, let's do that. Everett Scott riding on one. 25B704540.
Good morning, Judge. It's John Graziani, appearing on behalf of Everett Reinauer. Please identify yourself, sir. Everett Scott Reinauer.
Give me 1 second. I don't know what I did with my white out here. Give me white out down there. Okay, I'll adjourn this. Is a week enough or not?
Judge, we need 3 weeks because of the allegations that have been made, and this case is also going to be 4.5 years old, so I just want to be able to present.
Okay, give them 3 weeks, Lisa. We'll do the
December 16th at 9.
December 16th at 9.
Thank you so much. Please get there. Thank you, guys. Thank you, Judge.
Sir, you're gonna go down the hall and get your notice, okay? Go right down the hall and get your notice and you're all set.
Thank you so much.
No problem. Are you you're still my guy today, right? Or not?
Absolutely, Judge.
Okay.
Always a pleasure. I just have.
Okay.
There's just one more person.
Al Masawi. Abdul Rahman Ibrahim Al Masawi. 25X4615594.
Good morning, Your Honor. Rami Hijazi, P82830 on behalf
Can you
of
just start your
Almosawi.
video, please?
Your Honor, the prosecutor was having a hard time hearing me, so when I turned off the video, I could be heard through audio. If it's okay if I proceed without it.
Are you serious about going to a formal on this?
Your Honor, he just couldn't offer anything due to the nature of the the issue with the federal government where they can't reduce stuff. So
Asking, I get it.
Yeah,
I get it.
So that's all
I
that's
read it.
happening.
All right. So I'm gonna, Lisa, why don't we move this to December 9th? I can't go past that.
December 9th at 9:30.
At 9:30.
Thank you, Judge.
That's gonna be a formal hearing, so you guys are gonna have to be in person, okay?
No problem.
All right, thank you. Bye now.
Thank you, Judge. I appreciate your time. Have a good
No
holiday.
problem. You too. Is Andrea Young out? Yeah, there you are, ma'am. 25M615082, two people against Andrea Renee Young. Your name, ma'am?
Yes, Andrea Renee Young.
Today's your lucky day. The officer didn't show up. You're a winner. Turkey will taste better. Case dismissed. You're all set. Good luck.
Thank you. You have a
Thank
great
you.
rest of your day.
You too. Thank you. Tarico Montez Sparrow II, 17M705 9663FY. Okay, she's out of here. When Lexi Dan's lawyer comes back, we'll do that. Where you at?
And Messiah?
Okay. Let me just try to get through a couple of these, okay? Is Nelda Rodriguez back in here? Marcellus Lawler? Oh, that's the one. What did we do on that again, Lisa? I'm sorry.
That's the one we're waiting for the special prosecutor.
I see. Okay, so I got to put that one aside. And Rodriguez, and the only ones I have here is Don and Sparrow. What do you have?
You're on an exam for Mr. Andrew Siak.
Yeah, I know.
We also have a issue we'd like to discuss with the court on the co-defendants Williams and Brown that were just up on the dates.
What is it?
Signed last night, both of us, but this morning, I believe it's decent by now.
Who needs to talk to me? You and the prosecutor?
Co-counsel on the dates.
What cases are those?
It's Tiffany, I represent Tiffany Brown.
We already set that one.
Yeah, it's set for exam, and Mr. Williams is set for PCC on the second.
Jeez. Done.
Should I bring co-counsel in or just leave it as?
What, we can't do both on the second? Was there a reason I can't do?
Because she's pregnant 8 months and 1 week.
Well, I know, but I'm gonna get in the problem where he's leaving. I mean, she's pregnant. She's gonna be having a baby in 3 weeks. I don't want to schedule it for 4 weeks or 2 weeks. She can't do it. You're Ms. Patillo in 2 weeks. And I'm gonna set it for 4 weeks, and they're gonna be saying she just had the baby, right? I mean, I think I have to. I'll be glad to talk to you guys.
We'll leave it as it is then.
I mean, I'll be glad to talk to you if you got another idea. I'm ending the state docket the end of the year, and I try to get all these out of here before then, and I'm really starting to get backed up, I can tell. But if you guys want to talk about it, I'll talk about it, but
Thank you.
okay, I'll be happy to if you want to go talk to her. I do need to speak to Ms. Okay, you're set on that, Ms. Interpreter?
Yes, Your Honor.
Thank you so much. You ready? Okay, what happened to that file? Okay,
Yeah. I'm not.
so did he offer anything? You have anything on Melgar, Mr.
Well,
Hi, what are you doing on Melgar Rodriguez? Is there a plea or not? That's the one with the Spanish interpreter, the one I talked to you about? No insurance, Mr.
interpreter here.
You're here on that.
Here.
One in the hallway, one in the back. There's 2.
Well, Judge, I'll need Ms. Tepe to him to see.
Okay, well, wait a second. Wait. You're a Spanish interpreter.
Yes, Your Honor. I'm here for 2 individuals.
Okay, so I have a Spanish interpreter here. She was working on another case, so I'm gonna send her in to do Melgar Rodriguez as soon as she's done on this one. Which one do you have now?
Right now, it's Aurelio Zamora.
That's correct. We're ready to have it ready.
Guys, I know somebody's gotta help. Do you have the plea? Okay, Aurelio Zamora, 24G 306-2508. Perfect. Thank you. Okay, what do we have here?
Good morning, Your Honor. Attorney Porter, Westmoreland, appearing on behalf of Judge Stray.
You're all set. I'm sorry. I apologize. I'm going in 9 different directions. Sorry about that. Okay, your name, ma'am?
Shalana Heisley, HPI, SK1, operating English to Spanish.
All right. Raise your right hand, please. You solemnly swear or affirm that you'll make a true and accurate translation between the court and the defendant and his lawyer.
Yes, Your Honor.
All right, sir, state your name.
Aurelio Zamora?
All right, so we are here on a reckless driving charge. This is from November 24th of 24. He doesn't like to show up. I'm not going to put up with this nonsense. We're not bringing in interpreters only for you to not show up, sir. You missed on December 19, 24. You missed on January 16, 25. You came in November 10th. We set it for November 20th. I'm not going to play games. You want to play games? Go over to Sportway over there. I don't know what you're doing. I'm going to give him a cash fine. He needs to be doing this. Hope he has a lot of money. Where does he work?
On Friday, I will have you.
You're not getting it. We're not waiting until Friday.
Vamos a esperar hasta el viernes.
You think I'm going to keep bringing in interpreters for you, sir?
I do not need probably any cash. They pay me every other week.
Don't know what to tell you. You got a credit card? Great. If you don't, sorry.
I don't.
Sorry. 3,000, 10%. I'm not going to play this game with you anymore. He keeps doing this and not showing up, and it's the last time. We'll give him an early pretrial date. You have to post $300 to security release. I don't know what's going on, but I am not going to continue on this little journey. If he's working that much where he can't show up if you're working that much where you can't show up in court, you must have a ton of money. Sorry.
My client just showed me he has $25.
I'm not doing it. I'm not gonna keep letting people not show up. I'm tired of it. I mean, what's he doing? Walking in again late? I'm not changing my mind. At least I'll take the earliest date next week. December 2nd?
No, this is a local case, isn't it?
Oh, it is. Gibraltar.
December 4th, they're here. December 4th at 9:30.
December 4th at 9:30. I need a Spanish interpreter again that the court can pay a lot of money for. Sir, you're gonna end up paying all these interpreter fees. I just want you to know. You have to post $300 to secure your release. That's probably too low. Good luck. Thank you. People against, and then, I'm sorry, Ms. Heithley, or?
Yes, Your Honor.
Yeah, I'm gonna have them bring this file back on the.
Excuse me for clarity. Do you have the Alvin, Belgar, Rodriguez?
I do.
Okay, yeah, that's what we were looking.
Here it is, right here. Thank you. Stephen James Balint. 25I-718-829.
Attorney Porter was more than appearing on behalf of Mr. Balint. Mr. Balint, please wait to state your name for the record.
Stephen James Fallon?
Fallon, my apologies.
Does he stand mute, wait formal rating?
That's correct, Your Honor.
All right. He's in my sobriety court.
That's correct.
This incident predated the time in which he was accepted. I don't remember if it came. I believe this incident date preceded the drunk driving that he's in front of me on, but at any rate, I think he's taking good steps in sobriety right now. I'm concerned about the nature of the charge. He stands mute, waives formal reading.
That's correct, Your Honor.
Is anybody out there here on this case? Detective? No. All right. I'm going to give you a pretrial. I'm going to give you a $5,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. No contact at all with the victim. No assaultive, abusive, or intimidating behavior toward the victim. No contact with prosecution witnesses. You cannot enter you cannot enter 24111 Meridian Road, Unit 105 in Grosse Ile. No alcohol, no marijuana, no illegal drugs, no firearms, no dangerous weapons, no unsupervised contact, sir. You do not have any children, true?
Sure.
No unsupervised contact. I'm serious about this with any child less than 18 years of age. Do we understand one another? All right, so that's what I'm going to do. And I'm going to give you a court date. And this will be, what date it is a high court misdemeanor here. So I have to give them an exam and a PCC, Lisa. So I'm going to go ahead and set it for what, December 9th?
December 9th at 9 o'clock.
And then the 16th will be the exam at
10:30.
All right, that's what I'm doing, 9 o'clock and 10:30, okay?
Thank you.
All right, so you're going to go down the hall, get your notice. You're going to have to fill out a petition for a court-appointed lawyer going forward. He what?
He has retained counsel.
Oh, okay. Mr. Who?
Tony Carmen.
Oh, okay. Good enough. Good luck to you, sir. Go down the hall, get your notice, and notify your lawyer. Thank you very much.
Thank you, Judge. Have a nice day.
You too. Lesko, Jacob Joseph Lesko, 25M601345. Mr. Lesko, can you state your name, please?
Jacob Lesko.
Good morning to you.
Good morning, Your Honor.
Did you meet with the city attorney, the prosecutor yet?
I have not.
Judge, it's an informal.
Okay. Is Trooper Hadzik here?
No, he's not.
All right. Well, here's what I'm going to do. In fairness, you didn't show up timely. He isn't here today. I'm going to reset the informal hearing. I'll set aside the default judgment, okay? So I'll do that for you. I'll set aside the default judgment, but you missed once, he missed once. In fairness, I'm going to give him another chance. Do you want to do the 9th or the 16th, Lisa?
The 9th at 10:30.
The 9th at 10:30 in the morning. Okay, sir?
Okay.
All right. I wish you well. We'll see you here then. We'll set that for informal on that date. Default judgment set aside. If he doesn't show up next time, I'm dismissing and I'm going to refund you all the bond of money. Okay?
All right. Thank you.
Thank you. If you guys want to get those files, I'll be glad to talk to you about the date. I don't know what else I can do. You can get the prosecutor and we'll talk on both of those if you want.
For Mr. Lawler? For Mr. Williams? Oh, Mr. Williams.
There's no way you can zoom in at any point. Why don't you guys get those files? Which two do you need again?
Williams and Brown.
I already called both of those, right?
Yes.
I have them down here, Judge. You need them?
I do. Can you have somebody run them down?
Yep. Tiffany Brown and who else?
Williams. What's the first name of Williams?
Christian. I got
Williams.
it. Yep, I got it.
Okay, great. Thanks.
And leave that
I called that, but you weren't in here. I'd like to talk to you and Mr. Mohammed on that. Okay. Why don't you guys come on in on that? She'll get those files for me and I'll be out as soon as I can. Okay. Stay seated, everybody. Good morning, Miss. How are you? Nice to see you.
I just looked at that.
I'm Saturday, 11:09. Yes, sir.
Oh.
He wants us in change, right?
I was back there. I didn't hear a word he said about what he wants to do.
He wanted to talk to us about a case. You should come on.
Wants to talk to who?
Me and Muhammad.
All right, you want to grab Muhammad and we'll go back? Is that what he said? I didn't hear him. I don't know.
What? Just be sure. Okay.
Thank you, guys. Right.
Yeah, you know, Mr.
Mohammed right here.
Beyond the deal.
Ms. Petit.
Okay, I can send them new notices.
Perfect. All right, so if you get Ms. Patillo in here, I can handle this one.
You're welcome.
Yeah, it's kind of hectic. So Lisa, I'm going to call these two. This is People Against Tiffany Brown, 25M7168822 and 25M7168821. That's Christian Williams. They've already been told their exam dates and PCC dates. Your names, please.
Deanna TOP 82378 on behalf of Mr. Christian Williams.
Mayor, please, you found a court contract with HP 59229 representing Tiffany Brown.
So you correctly point out, we can't have two different exams. And I didn't realize when I called these, they were co-defendants. So we're going to do December, we agreed on December 2nd as a PCC, December 2nd on both cases at 9:45. I set one of them, Lisa, for 9:45 before, that's Ms. Williams. But I set Tiffany Brown for 11. So we're going to move that to the 9:45. So the PCCs on Williams and Brown will be December 2nd at 9:45. Preliminary exam will be December 9th. And because the lawyer has a problem, one of them, and it's hard when you got these co-defendants, obviously, I'm going to move it till 2:30 p.m. One of the lawyers. Now, if you guys can get here earlier, that would be fantastic. If you can't, you can't. But if you can, I'm just saying. So if everybody shows up early, we can start, okay? Thank you. Now, he has to give me that other file. I was afraid I wasn't gonna bet. I'm gonna see it. Hand it up, please. Okay, I'm gonna need the interpreter momentarily. People against Sparrow, Tarico Montez Sparrow, the second 17M 705 9663. Good morning, Mr. Sparrow. Your name?
Good morning, sir. Tarico Sparrow.
All right, your name?
Deanna TOP 82378 on behalf of Mr. Sparrow.
So we're now going to I talked to your lawyer further. She's got some conflicts. We're going to do your PCC December the 2nd at 9:45, right? Is that what we agreed on?
Yes.
And then December the 9th, we can still do that exam at 1 p.m. Okay, so you can show up and do this one, and then we'll have the other case at 2:30.
Okay, thank you, Judge.
Thank you. I know you got to get out of here.
More, I think, though, the special prosecutor one.
Have we seen the special prosecutor?
No. If you want to set dates, I can contact her later and give them to her.
But you know, the problem with them is that I'll do this for Ms. Patillo, but problem with them is they're all over the place. Which one was that again?
Lawless, Marcellus Lawless.
You have that.
Those different prosecutors.
Well, I'm gonna have it. Ms. Tucker, are you here in court still? Wait 1 second, Mr. Lawler.
Okie dokie.
You know, Mr. Muhammad,
Yes.
you don't want to do this with these plans, these programs. I told you that. Talking about basic driver improvement program. I'll talk to you in a second.
The judge, we're adjourning it.
I'm not.
Oh.
Melgar Rodriguez. Perlin Antonio Melgar Rodriguez, 25M 608632.
Good morning again, Judge and staff. John Graziani, appearing on behalf of Maryland, Rodriguez, Judge.
Your name?
Erling Antonio Melgar.
And your name?
Shalonda Heisley.
Ms. Heisley, thank you again. You're certified interpreter through the state, correct?
State qualified.
State qualified.
Well, 2018, yes, Your Honor.
All right, and you already took the oath on this, so you're still under oath. For purposes of arraignment, does he stand mute and waive formal reading?
He does waive the arraignment and states
I'll enter a not guilty plea. Now, you negotiated a great deal. He's going to plead to no proof of insurance, right?
That's correct. The civil infraction portion is.
So no immigration consequences or anything. To the charge, no proof. Do you understand that and agree to that, sir?
Yes.
To the charge of no proof of insurance, responsible or not responsible?
No, I'm Responsible.
All right, I'm gonna charge you 185 plus interpreter fees of 50, okay? So your total's 235. I'm dismissing the no insurance claim. Yeah, okay? Thank you.
Are you in a position to pay this today, or do you need some time, sir? So
the 235?
That's correct.
Yes, I can do that.
Perfect, thank you.
Thank you so much. Thank you. Talk with Mr. Burton.
I just had Andrew Siak here somewhere. Andrew Steven Siak. I do. 25T7174451.
Are we on the record?
We are.
Good morning, Nora. I'll be on behalf of the people.
Mayor, please assign a point on Huck Davis, P59229, representing Mr.
Oh, wait, this is the exam.
Yes.
You can't do this and leave all these lawyers waiting right now. I'm sorry. I'm sorry. Justin Cole. 5B149451 A, B, and C. So I don't want to do this. I got to tell you, this is a blight case and improper lights. What's a driving improvement course going to do? Your name?
Yes, good morning, Your Honor. Mohammed on behalf of the people.
Your name?
Judge Lawyer. And Judge, it's not a driving improvement course. It's a better decision-making program.
I don't do programs on civil infractions. I just don't want to do them. I did one because you guys worked it out on some other case.
No, so we were going to have the respondent complete that program first, and then I'll.
What? Better decision making. What was he doing there, supposedly?
He failed to disclose his CPL license.
Oh, that's just silly. The improper, so you think this program's gonna help him disclose his?
Yeah, so he provided a video associated with the incident, and I think the situation could have been handled more professionally.
By who?
By the respondent.
Okay.
And I think this
You
program.
weren't getting smart with somebody out there, were you, Mr. Cole?
Yeah.
Okay. Yeah, he was?
I'll leave it for the opinion of the court if they view the video, but nonetheless, upon reviewing that video, I think his conduct could have been more professional. He also, at some point during the interaction, did disclose that he had a CPL, but this was after there was initial contact with the officer. The officer was back in his vehicle, and whether or not he disclosed it to the point where an officer heard him, though, I don't know. So I think if he completes this program, in the interest of justice, I would dismiss that failure to disclose. It is a civil infraction.
It's been going on since October 2nd. I gotta tell you, I'm kind of a rule follower for whatever reason. Supreme Court tells us we're supposed to have 100% of these civil infractions adjudicated with 126 days, 98% within 91, and 90% within 63. Now, this case is already 5954 days old. I adjourn it 3 weeks, that's 21 days, that makes it 75 days old. I just don't want to get in the habit of doing these programs. I mean,
How about a 1 week?
adjourn it 1 week.
Thank you.
1 week. That's it, though. You can get that done, Mr. Cole?
Yes, Your Honor.
You weren't nasty with the officer. You wouldn't do that, right?
Just ask me bad number, I guess.
Why'd you ask him his bad?
I always just make a lot of contact with them.
You gonna ask me what my P number is? I mean, really?
No, not you, then I have some contact with you, but like, these officers are always addressing and usually do that, so I know they're.
How about their name?
I can
December 2nd, Lisa, at what time?
O'clock,
I'm sorry, you kind of
10.
cut out.
10 o'clock.
Okay, 10 a.m. All right.
All set.
I'm gonna do this for you, Mr. Cole, but The prosecutor's not gonna do this to me again, right, Ms. Mohammed? No more courses. We don't need courses to help us make better decisions and be respectful of police and authority, and for whatever reason,
Yes, sir.
I'll never learn that, but that's neither here nor there. I'll see you here on the second. Get that taken care of, and I think he's gonna cut you a break. Marcellus Cortez Lawler, 25E725-167. Your name, sir?
Marcellus Lawler.
Good morning, Judge Deanna Tepe, 82378 on behalf of Mr. Lawler.
What day do you want?
CC?
Yeah.
With the second?
Good. 12/2 at 9:45 again?
Yes.
And then the exam, we could do December 9th if you want at 1.
Yeah, that works.
Okay, so those are your dates, sir. December 2nd, 9:45 PCC. You can appear by Zoom on that day, but on the 9th, 1 PM.
Okay, and that's in person, right, on the 9th?
Correct. Correct. Good luck. See you then.
Thank you. Now, I have a question. Who is my attorney?
Me,
Her name is Dion Patia.
I can give him my phone. You can call 313.
Hold on, let me get a pen. I don't have one.
My God.
Hold on one
I'm
second.
telling you. I'm telling you. Ryan Tarrant, listen. Why don't you give her your number if you want to? You don't have to. We're on Zoom. How can I do this, Lisa?
Okay, yeah.
You tell me
Well,
I should be able to
my
defend-
telephone
give her
number
on
is
Zoom now.
My telephone number is 248-379-0469.
She'll call you. How's that? You'll call him, Ms.
Yes.
Patil? She's a good lawyer. We'll see you here next week. Thank you.
All right, thank you.
All right, let's go on to, what are we doing on Strickland? Who's got Strickland? You?
I do.
Where is he?
He's here.
Ryan Taran Strickland, 25E726-598. We're doing an exam on this case too?
This is scheduled for an examination for today.
I know. Is that what we're doing?
Yes, and good morning, Your Honor. Mohammed on behalf of the people.
Deanna Tepe, 82378 on behalf of Mr. Strickland.
Sure, your name?
Ryan Strickland.
Is that what we're doing, is going to exam?
Yes, Your Honor. So the people are unable to move forward today for the preliminary examination. No one has appeared despite subpoenas being issued. I've had an opportunity to speak with the detective who is here in person, Detective Platt. It's my understanding that the complaining witness has informed me that she does not wish to prosecute.
Your Honor, she said I served her yesterday with the subpoenas. She told me she was not coming to court.
Well, that's nice. They shouldn't have to come to court and if they want to disobey a court order, they should be able to do that, right? That's where we've gotten kind of, right? I mean, does she understand a subpoena is in order to appear? You know, I've said this for years. I don't understand why they're not show causing each
You
other.
gotta take that cell phone out of here.
Cell phone out of the building, sir. Out of the building, please. You know what I mean? It's just crazy. So they make complaints. We have court dates. Police do investigations, submit them to the prosecutor's office, issue warrants, do arraignments, and then they decide they don't want to go forward. But the bigger thing is, the problem I have is if they don't want to go forward, that's one thing, I suppose, for sure. But the other is just ignoring subpoenas that are personally served on them. And that can't be done. You move to dismiss?
Yes, Your Honor, based off of the complaining witness's failure to appear, I would ask that the matter be dismissed without.
I'll make a note. Complaining witness failed to appear, does not wish to proceed. And you don't have any response, right, counsel?
No.
Okay, Lisa, I'm concerned about this one, and I don't want to go too fast here because there's all bond conditions here. Was he ever fitted with a GPS tether? So we got to take care of all of that. We got to cancel the bond conditions. The case is dismissed on motion of the defense. Prosecutor does not, or the complaining witness does not wish to proceed. And we'll go from there, okay?
He'll get an order to have the tether removed.
Yeah, he's got to go down and talk to my judicial clerk, but he's going to need to be patient, okay?
Okay.
Just be patient, sir. Don't go anywhere, all right?
No.
No, go down the end of the hall and you point out who you are and we'll go from there.
Thank you, Judge. Happy Thanksgiving.
You too. Thanks a lot. So I got SEAC that's going through exam. I've got Lexi Dan. Lexi Dan. By the way, Ms. Tucker, are you just waiting or who's waiting on that one with the special prosecutor? Ms. Patillo?
Yes. For UPL.
Get her in here, will you please? Did I already call that,
Yeah.
Lisa?
Judge, we set dates on it and I'm going to notify her.
Thank you. Good. Okay. Lexi Jane Elaine Dan, 25B 724-898. Ma'am, your name?
Your Honor, Miss Dan, I think was logging on to Zoom. I don't see her.
She's not in the waiting room.
I will call right now.
You know what I'm gonna do? Unless these defendants on felonies are with their lawyers in an office, unless they live more than an hour away, they're gonna just have to do this horrible thing and show up in court. I'm just done with this. I really am. You guys ought not have to be going crazy, putting people in breakout rooms. That's just the way it's gonna be. That's just the way it's gonna be. Okay, I get tired of calling cases 2 and 3 times and they're disappearing on us. I mean, Nicholas A. Peros, is that going to exam?
No, Your Honor.
25T 726-118. Come on up, Mr. Peros. What do we?
Mr. Mohammed.
Please. Come on up here, sir. Good morning to you.
Good morning.
State your name.
Nicholas A. Harris.
Mr. Darren?
Nicholas Parent, Mr. Paris, who stands by.
That was an impressive jog across the courtroom. Nice.
Still spry, I mean.
Thinking, should have been a running back for Notre Dame or something. Mr. Mohammed, your name?
Good morning, Your Honor. Mohammed on behalf of the.
What are we doing on this one?
Go ahead.
Your Honor, it's my understanding that the complaining witness has failed to appear. The people are unable to move forward. Subpoenas were issued. I've spoken with the detective in this case. He did notify the victim on this case. It was actually his understanding that they would be appearing. However, they have failed to appear.
You know, I hope when they do this, you're not going to reissue. I mean, if they just had to go out to lunch or something or needed to go, buy Christmas gifts that day, I hope you guys aren't going to reissue. I can't force you not to do that. You move to dismiss, case dismissed. I mean, I just don't get this. Changing bond conditions again on this. Give me 1 second. He doesn't have a tether, does he?
No.
Okay. Good luck to you. Nice to see you, Mr. Darren. Have a nice Thanksgiving, sir. Take care. Thank you. You too. Okay, so I've got SEAC up here. I got Don up here. I think we can probably, is this Ms. Lynch? Is she on the one case?
Yes.
So, Ms. Lynch, I already called that, right, Lisa? I'm so sorry.
Yeah, you did. Yep.
So, Ms. Lynch, I'm kind of easy to get along with, not overly easy, but in the future, if you can just let us know. I had the other lawyer needed to leave, and I don't know what your schedule is. I sent dates, but maybe you can chat with us if you're getting tied up. At least you can give us some available dates, because I'm coming to the end of my docket. And I've got to conclude this pretty quick. So I'll ask you to do that. Lisa, why don't you give her the dates and times?
The PCC is December 2nd at 9:45.
And that should be good because that was the date for the exam, was it not, Lisa?
I believe so. Yep.
Okay.
And the exam was December 9th at 1.
Are those good with you?
I'm just looking, December 9th at 1. On the 9th, I will be in Detroit with a preliminary examination that will begin at noon.
Who was on that one? Who was on
Ms.
that?
Patillo. It was Ms. Patillo.
That's
I
why
would be
gotta
available.
have you guys.
I think you're still in the
I
village.
would be,
Yeah, get Ms. Patillo.
She does have an exam that day at 2:30 if you just want to move it back a little bit.
I can move it to 2:30 for you.
2:30. That could be pushing it because the 36th District Court runs late, but I would be available in the afternoon on the 10th.
Yes.
On
We
the
don't do
11th. Special prosecutor.
Ms. Patillo already left, but this is why you gotta let us know. We don't have the time to be working
Well,
on
you're-
schedules. I don't know what,
We're sure.
Ms. Patillo, come on back up here. Give me the case number, Lisa. What was the case again?
25B 725-167 Lawler.
Marcellus Lawler, right?
Yes.
All right, your name again?
Yeah, Patillo, P8237A on behalf of.
All right, Ms. Lynch, your name?
Dinah Lynch on behalf of the people, P84589.
So we're going December 2nd to the PCC at 9:45. Now we have to pick a new date. She can't do the 9th. So we're doing the 2nd at 9:45. If I misspoke, let me know. As a PCC.
And
She's not available on the, I'm sorry.
I'm not available on the 9th, but I am available on the 10th, 11th, or 12th. I'm
How
at
about-
trial that entire week afterwards.
How about,
So I'd be available.
can you do the 10th?
Yes, in the afternoon.
Well, I was asking Ms. Patillo, can you do the 10th?
I can, but it would have to be.
Or the 11th? Can we do the 11th, Lisa? 10th, I might have sobriety court, don't I?
The 10th, yes, and you do have an exam at 1 o'clock with another special prosecutor.
How about the 11th?
The 11th, you're good in the afternoon.
How about, can you guys do the 11th at 1?
I can. The people can.
No, I can do them earlier. I have an 11 a.m. Exam in Detroit.
Well, how are you gonna do it earlier?
10 o'clock.
What kind of case is that again? I don't have the file in front of me. I don't remember what it is. Can you guys tell me?
Adult abuse
Yeah.
and assault aggravated.
Vulnerable adult abuse.
Okay, so you can't do it the 10th, right? And you really can't do it the 11th. You're gonna be in Wyandotte at what time?
So Wyandotte is 1:30 and then 11 is Detroit.
How about the 12th?
I'll do it in the 12th, on the 12th, first thing in the morning. If you guys want to do it on the 12th at 8:30 or 9 o'clock, but I'm going to expect us to start on time, okay?
So I have an exam on the 12th in Detroit at 9.
You guys are killing me.
Do the.
I mean-
I could do the afternoon on the 12th.
I'm not doing the afternoon on the 12th. Sorry, it's Friday.
Oh, no, that's fine.
I'm not
I
doing
was just
that.
throwing it out there. Mhm.
What about
Then I
the
would be,
10th in the afternoon? I could do the afternoon in the 10th.
Didn't you have a problem with that, Ms. Lynch, or not?
I do not. I did not. I thought Ms. Patella did.
But I have a problem with that then, right, Lisa? Something,
You have a 1 o'clock exam on a welfare fraud case
and I've got sobriety court,
and sobriety court.
and that's a graduation day. I just
What
can't.
about the 8th?
In the afternoon?
Yeah, the
Yes.
8th, that's a Monday, right?
Yeah, you're good in the afternoon.
Or wait, is that a Monday? Yeah, you
Yep.
can do it the 8th?
I can do the 8th.
Okay, let's do it the 8th at 1 o'clock.
Thank you very much, Your Honor.
All right, no problem. Thanks a lot.
Thank you. Have a good,
That PCC is still the 2nd at 9:45.
Correct.
Okay, all right, thank you.
Thank you.
all right. Happy Thanksgiving, everyone.
Same to you. Thank you very much. People against Lexi Jane and Elaine Dunn, 25B 724-898.
James Sherman on behalf of Ms. Dan.
Good morning, Ms. Dan. You've been patient. Your name?
My name is Lexi Dan, Your Honor.
I'm sorry I went through all of that. I really am, but
I actually
not-
appreciate it, Your Honor. So I thank you. I thank you.
No problem. I'm gonna cover this. I'm looking forward to having you in our sobriety court. You're ready, right?
I'm very much ready, Your Honor. I am.
Now, I want you to know something. I don't mind doing this for you, but you're going to go through a bond phase. And I'm going to expect you to get through the bond phase. And I'm going to expect you to complete the program.
Yes, Your Honor.
This is not for the weary. Okay? This is simply not for the weary. There's nothing easy about sobriety court. Okay? So
I
let's
understand,
start
Your
with
Honor.
that. They have me having you plead guilty to 2 charges. OWI 1 occupant less than 16, and child abuse in the 4th degree. They're adding that count, right, counsel?
That's correct.
And then all other charges will be dismissed, right?
Correct.
Okay, now. Okay, so this was actually, there was never a felony here, right? Or was there? Yeah, there was on the count 1, because the second or subsequent events notice, because she had that previously. So they're going to take and reduce this felony for you to a 1-year misdemeanor, and I'm glad to do it. But I'm telling you, even though you heard the conversation, I disagree with tying judges' hands and making judges or expecting judges to do what prosecutors tell them. But I'm not going to be easy here. And I don't want to sound negative. I want you to understand, I need your full-blown cooperation. We're going to put you on a bond regimen. Since they're cutting you such a deal, there's no conditional plea here. If you don't get through the bond phase, write this down. You're going to do a year. Do you understand that?
I understand, Your Honor.
We will work with you. We want to help you. You seem like a nice person, but I'm telling you, there's something about, I want to treat you with respect and dignity, but I also want to make sure that you understand I'm going to hold you accountable. Do you understand that?
I do, Your Honor. I do.
So if you plead guilty to child abuse in the 4th degree, that's punishable by up to 1 year. If you plead guilty to OWI occupant less than 16, first offense, that, ma'am, is punishable by up to 1 year. But I want to go through these conditions, and this plea is going to take a minute. Sentence agreement of 60 to 90 days as jail, as determined by the judge, with work release if eligible and available. The jail condition may be waived at the discretion of the court if the defendant completes a specialty court program pursuant to statute. The court can impose jail at its discretion for child abuse 4. The OWI 3 charges will be dismissed at sentencing provided the terms of the agreement are satisfied. They got a sentence agreement, 2 years probation with sobriety, drug, veterans, or mental health court. The defendant will need to find placement on or before sentencing, no early termination of the probation. Any SCAO approved sobriety or specialty court will be acceptable. The 33rd District Court program is acceptable. In addition, all their terms set by the court, costs of prosecution is determined on alcohol, drug screening, and treatment. Full restitution for any out-of-pocket costs for damages or harm incurred because of the offense on or before sentencing, if applicable. In addition, a parenting responsibility class should be included. So now I'm getting to another point here. Strong recommendation. If the defendant fails out of the sobriety court or specialty court due to poor performance, commits another crime while on probation, the judge finds sufficient cause to terminate probation. The Wayne County Prosecutor's Office recommends the balance of the year or 1 year must be served in jail. Stipulation that the sentencing agreement and second OWI offense are sufficient grounds for incarceration if it's imposed. The violation of probation terms are a recommendation and at the discretion of the court. Courtroom APA must be notified if any of the above violations are committed. So now they're getting into, if he doesn't get through the bond phase, for me not to dismiss the OWI 3 charge. Okay, I'm still going to go along with it. This is just belaboring because we used to not take conditional pleas. So I want you to understand, if you take this plea and you don't get past the bond phase, the plea's going to be set aside and you're going to be charged, you're going to have an OWI 3 or a felony charge on your record, or at least one that you're going to have to contend with downtown. Do you understand that?
I do understand, Your Honor.
Now, what else?
Your Honor, you expressed some concern about the parenting responsibility class. She's already enrolled in that class, so that should be done relatively soon.
Parenting, no, I wasn't talking about the parenting. I was talking about the OWI 3 being dismissed its sentence. So you understand the possible penalties, true?
That is true, Your Honor.
All right. And you read all these rights? You went over these rights on the advice of rights form with your lawyer?
I have, Your Honor.
And you understand that you're giving up your right to a jury trial. You're giving up your right to remain silent. You're giving up your right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. And that silence will not be held against you if you choose to exercise that right. Do you understand that?
I do, Your Honor.
By pleading guilty, you're waiving the presumption of innocence. You're waiving the burden of proof of beyond a reasonable doubt. You're waiving all these requirements, including your right to a trial. And I will then take your plea pursuant to this agreement. Do you understand all that?
I understand.
And you understand the possible penalties are up to a year. I don't know when she had her prior counsel. Can you tell me?
I'd have to look up and
It
file.
was 2018, Your Honor.
Okay.
It may have been 2019 if I'm mistaken. I'm sorry about that.
Yeah, it was April 30th, 2019, according to the complaint. Let me just double check the other paperwork here. Yeah, so I want you to understand, if you own that vehicle, I have to order a mobilization of that vehicle for 90 days. Your license will be revoked after this plea. Do you understand that?
I do, Your Honor. And are we talking about the vehicle that I was driving when I caught this CUI this time?
Yes.
Okay, I do not own that vehicle, but I do understand what you're saying.
Who owned it?
My friend Forrest. He still has it. He still drives it to work every day. I don't drive it at all anymore.
All right. We're gonna have to double check that. So we'll try, maybe you don't have to do it now, Lisa. Just try to do it before the sentencing. Okay. Do you have any questions before I ask you how you plead?
I do not, Your Honor.
All right. To the charge of child abuse, how do you plead?
I plead guilty, Your Honor.
And to the charge of OWI occupant less than 16, first offense, how do you plead?
I plead guilty, Your Honor.
All right. You had a prior offense on April 30 of 2019, correct?
I did.
And that's when you were convicted of operating while impaired out of the Romulus Court, 34th, right?
That's correct.
And on this date, October 12 of 25, were you operating a motor vehicle in the township of Brownstown? And prior to that, did you drink alcohol? And if so, what did you drink and how much?
Yes, I did, Your Honor. And I drank the 2 little small bottles of wine. They come in a 4-pack. And then I drank 2 single airplane shooters.
All right. And did you have a son, or do you have a son by the name of Josiah Davis, date of birth, December 16 of 23?
I do, Your Honor.
And he was in the vehicle at the time, correct?
He was.
And was your ability to operate that motor vehicle significantly and materially affected due to the consumption of the alcohol? And if so, in what way? Why were you pulled over by the police?
I was driving down the road with my right turn signal on and my headlights off, Your Honor.
Did you ultimately get arrested?
I did, Your Honor.
And were you transported? Did you take a toxilizer breath test at the police station, or did you get a blood draw?
I did do the tox screen at the police station, Your Honor.
Okay. And what were the results of that, counsel? Can you tell me?
I can look it up real quick, Your Honor.
Do you know what they were, Ms. Dan?
I believe they were. Go ahead.
Sorry.
Detective, your name?
Detective Crystal Tulas, Brownstone Police Department. The results were a .224 and a .223.
All right. Any reason to dispute the accuracy of that reading, counsel?
No, Your Honor.
Are you on probation or parole right now?
I am not, Your Honor.
And at the time that you were operating this motor vehicle, again, when you had that high breathalyzer result with no headlights and no turn signal, was your son in the vehicle in a
He
car
was, Your
with
Honor.
you? All right.
He
And where
was.
was he seated? In the back seat?
He was in the back seat, secured into his car seat, Your Honor.
All right. Are you on probation or parole right now?
I am not, Your Honor.
Anybody in the world force you to plead guilty?
Nobody did, Your Honor.
All right. You satisfied, counsel?
Satisfied, thank you.
All right. We're going to reduce this. This can be OWI occupant, less than 16. And you're sure you're going to be able to get in child abuse fourth. And I'm dismissing all other charges. You understand, on motion of the prosecutor, you understand you're going to have to, this is almost going to be like a second home. You're going to be here every week. Do you understand that?
I do, Your Honor.
I'm going to order a screening and assessment. All other charges are dismissed. You're going to have to come up here for an intake. And then I'll set a sentence date. Can you come today?
I have to be to Detroit to do my tether between 3 and 5, and I also have, I do intense outpatient
Hang on one
counseling.
second. Hang on one second, ma'am. How about if I have her come in? It's a felony reduced to a misdemeanor at sobriety court coming tomorrow. Is that good in the morning?
Yep, that works for me.
Good. Thanks. Thanks. I'm still online. Thank you. Yes. Thanks. Bye. This is going to be sobriety court at 8. You're going to come in here at 8:30 in the morning for screening and assessment tomorrow. Your job is to comply with all bond conditions. You've been going to AA, right?
Yes, I have, Your Honor.
They're going to, and I'm not dismissing the OWI 3 until we accept you into the treatment program. If they're going to set you up with weekly testing, you're going to have to pay for at least until you get through the bond phase.
Okay.
You've got the, you have a scram tether?
I do, Your Honor. Yes.
All right. So we might want to convert that to a sober link. Unless you have a problem with the sober link. Did we talk about
Your
that?
Honor, I'm very comfortable on my tether. I mean, if
Okay.
you're doing it for financial
fine.
reasons, if
Yeah.
you're doing it for financial reasons, then I understand that. But I'm very comfortable on my tether, and I would actually like to keep my tether until my baby's born.
Okay. Well,
I would.
okay. So we have a grant, and anyway, we're not paying for any of that right now, but we will when we accept you into the program. Okay.
Okay.
There might be an issue with you having to pay the difference over a sober link. Scram tether's a little bit more. You gotta get done with this stuff, right?
Yes, Your Honor.
How old are you?
I am 33 years old, Your Honor.
I mean, you know, the next one you get is a felony, right? And
I do
life,
know
as
that,
you
Your
know,
Honor.
will no longer be the same. Why don't we put this out until right after the first of the year, Lisa, like my second week?
January 7th at 8:30.
All right. So I'm not dismissing. OWI 3, not dismissed. I feel like sometimes with these plea agreements with the prosecutor's office that I got to cross every T and dot every I, or they're gonna, well, I got you. You know what I mean? But I'm not going through that colloquy with them about conditional pleas. So we'll just go ahead and do this. You're all set. You make sure you come in here at 8:30 in the morning tomorrow.
Now is this your court down here at, is it the 33rd?
It's the 33rd.
Okay, and I'll be able to find it. Somebody will help me get to where I need to go.
It's right on Van Horn off of Allen. Just Google 19,000 Van Horn in Woodhaven. Who's
Okay.
this behind you?
Oh, it's Billie Eilish. It's a poster, Your Honor. I'm sorry.
Geez, I'll come
It's a poster. I'm sorry. I'm in my
You're fine.
daughter's room.
You're fine. Take care. Have a good day.
Thank you, Your
very
Honor. I
much.
appreciate
Thank
you.
Thank you. Good luck.
Your Honor, I understand there's a defense counsel assigned to sobriety court. Do I still do the sentencing myself or?
Oh, yeah.
Okay.
Oh, yeah. We're gonna want you here. Absolutely.
Okay.
Thank you.
Yep.
Alyssa Leanne Young, 25B 718. Lisa, is this, it says Judge Heston on some of these. Is this? No, it just was in the beginning, right?
I check.
I think it's probably, no, I think that was just because it got reassigned.
Yes, it was reassigned.
Where's Mr. Graziani? Do you see him out there anywhere? All right, Alyssa Young, Alyssa Leanne Young, 25B 718-619. Mr. Grett. You're good. Come on in, Mr. Graziani.
Thank you, Judge.
All right, your appearance, this is Alyssa Young.
Record, John Graziani appearing on behalf of Alyssa Young.
I'm going to go ahead and issue a warrant and forfeit the bond.
Judge, if I may, this is a situation where a person has sporadic transportation. She does work. She has 4 children. I know Mr. Mohammed would be with you on that, but again, this is a very.
Well, where didn't she didn't even call. She didn't show up at all.
I understand, but it certainly doesn't make any sense. She said she was, going to be over here, and she also indicated that she was interested in the offer that was made by Mr. Mohammed. So it doesn't make any sense, Judge, so I would ask for an adjournment for at least a week.
Good morning, Mohammed on behalf of the people. We would motion for a case as the defendant has done.
Was there an offer that they're going to take?
Judge, I don't recall the offer, but if the defense counsel is representing that I extended an offer previously, then I'm sure I have.
He did, Mr. Mohammed did extend an offer. She said she'd be thinking about it. It certainly doesn't make any sense, Judge, and as a result.
Yeah, but sometimes, she was here October 14th, 28th, 4th. I don't know why she wouldn't show.
Certainly doesn't. That's Judge. That's fine.
I mean, if you want to, I just can't. I'm sorry. 5,000, 10%. If you call her and tell her to come in, I'll lift the woman.
Okay.
Okay?
Thank you.
Thank you very much. All right.
Waiting for Burton to try to get out.
Terry Ann Miller. Terry Ann Miller, file under 25B 716-9042.
Judge, he's at MDOC and they have not logged in yet.
Okay, I'll put that one aside. How about Ferguson? Kobe Rashard Ferguson, 25B 725-812. Oh, this is until 1 o'clock.
Yeah, Judge, I had those 2 files, the 2 CSCs in my office. I just brought them out because I'm not prosecutor on those cases.
Yeah, we're not doing those till 1.
Yeah, but I'm not the prosecutor on those cases. So that's why I returned to the court.
Nice.
Yeah.
We'll hold these till 1 o'clock. Now we're going to do SEAC. Wait a minute. Terry Ann, oh yeah. Where's Mr. Coleman? Is Mr. Coleman here?
I haven't spoken to him today.
He's actually on the phone saying that he's been in the waiting room, but I don't see him.
Mr. Johnson.
He showed up late last time too by quite a while, didn't
He actually showed up a couple hours early and I messaged him and said, this is not set till 11.
he? All right, so we're holding those. Let's do Andrew Stevens SEAC. 25T 7174451.
Good morning, Your Honor. We're all the way on behalf of the people.
Mayor, please, the son of a court, John Pepper, latest P5, representing Mr. Andrew Stephen Seat.
Mr. SEAC, your name, sir?
Andrew Stevens here.
You're gonna behave today, right?
Yes, sir.
You're not gonna act like you did last time, right?
No, sir.
Okay, because if you do, we're gonna have a problem, okay?
Yes.
Good. All right. You can have a seat, sir. This is the time and date scheduled for a preliminary exam. I have a one count assault with intent to do great bodily harm less than murder or by strangulation. The other two are 93 and 1 year misdemeanors. So there's no right to an exam on those. Any preliminary matters on this, Ms. Allen?
This is a co-defendant case. In both Anderson, I have somebody named Juliana. It's listed on the information.
Right.
I want to make sure, I believe she has been KPS'd in the past. I know that there's that warrant out, she hasn't been here.
Lisa, can you check on that?
What's the co-defendant's name?
It's Breanna, Breanna. Love, L-U-V. Last name is Pett, P-E-T-T.
It's in warrant status. She's never appeared.
Just want to make sure that everything was fine on that.
Okay.
And also the assault and battery charge is for her, to see on the information. So, the felony charge is not help. If I wrote the information for her.
Well, that's correct, but she also was charged with assault or assault and battery as it relates to count 2.
Yeah.
So that's the only count pending against her. Okay. Anything else that you want to bring up before we start?
Well, sequestration, but I don't believe anybody in this court was a witness to the incident.
All right. Any of the individuals out here are going to be witnesses today for you, Ms. Tucker Davis, or at the time of trial?
No, Your Honor.
Okay, all witnesses, with the exception of the officer in charge and the defendant, are to leave the courtroom. Any preliminary matters from you, Ms. Tucker Davis?
No, Your Honor.
Call your first witness.
Your Honor, I want to make clear to the court, I will be moving forward on MCL 768.27C based on the statements to the officer. We do have to complain here today, but I will have the officer testify it.
Okay. Everyone's calm.
And we would make our standing objection to that for the right of confrontation with the complainant, Your Honor.
Thank you.
And would you like me to respond, Your Honor?
Yeah, go ahead. I mean, I think we take it up one at a time, frankly, as he starts to testify. You can lodge your objections. If you're basing it on hearsay, I don't know if it's going to fall within a rule, an exception or not, but otherwise, let's just play it like that. You can feel free to stand up and object on any of the statements, okay?
The statute, evidence of a statement by declaring is admissible under 1E, if that statement was made to a law enforcement officer.
Right.
And so at this time, the people call Officer Garrett Hughes.
Okay.
I not.
We're all set on the police dominating, leading the sheet.
Okay, officer, come on up here.
Leslie Charlotte, I don't think chair, I apologize. The officer charged say that they picked up Officer Treviniak. He's here filling in.
Okay.
Officer charged.
Sir, raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I do.
All right, have a seat, please. Can you state your name and spell your name for my recorder, please?
My name is Garrett Hughes, Garrett, last name Hughs.
Thank you, officer. You can proceed.
Thank you, Your Honor. Mr. Hughes. Where do you work?
Trent Police Department.
And what do you do there?
I'm a patrol officer.
What are your roles and responsibilities within that role?
Well, I'm sorry.
I'm sorry. What are your duties and responsibilities within that role?
Patrol the streets, and just doing traffic stops, responding calls when citizens call.
How long have you been working there?
Just over 2 years.
So I'm going to take you back to June 22nd, 2025. Were you working that day?
Yes, ma'am.
Do you recall were you on dispatch or patrol that day?
On patrol.
And were you dispatched excuse me, to 3911 4th Street in the city of Trenton?
Yes, I was.
And was it apartment 221?
Yes,
And that's in Wayne County?
correct.
Do you recall what the reason you were dispatched to that location was?
Yes, the call came out as an assault that just took place where the suspect just fled before us getting called.
And when you got there, did anybody identify themselves to you?
Who entered the door? Yes, it was Miss Shelley Xavier. She entered the door being very emotional, with a bloody nose and a very dark black left eye.
Were those your observations of her that day?
Correct, yes.
Do you recall what time it was?
I believe it was just before 1 o'clock in the morning.
And did she say anything to you?
Objection.
I mean, what was your emotional state at the time? You said she had a bloody nose. She had a dark black eye.
Yes, sir.
What else was her physical demeanor like?
She was crying, she was upset.
It's clearly an excited utterance. You don't even need to get to that statute, so I'm gonna overrule. Go ahead.
And I apologize. What did she say to you?
He said he did it and he had gone.
And did she tell you what she meant by that?
Well, with my previous experience dealing with that apartment and the calls, I knew who she was talking about. It was Mr. Andrew Siak.
And did she at all that night tell you his name?
After I got in and started talking to her, yes.
And did she identify, and regarding that sentence that she had said to you about he did it and he's gone, did she tell you that she met Andrew Siak?
Yes,
And do you see him in the courtroom today?
I did.
Could you please come up there and tell me what color shirt he's wearing?
Gray, white.
Let the record reflect the witness has identified the defendant.
The record should so reflect.
And so what did she tell you about it?
She told me that Mr. Siak and there's an argument over a dog involving Mr. Siak and his daughter. Mr. Siak and his daughter went to a pride event and left the dog at the apartment. And Ms. Zajic had no recollection of an agreement of leaving the dog there.
And let me stop you there. What did you say? A parade? What?
Pride.
Event?
Pride event.
Oh, pride event. Okay. And so you said there was an agreement about the dog. Was she at the apartment?
Who, the daughter?
No, Shelley Sage.
Shelley was there, yes.
And what else did she say after that?
So Shelley was upset that the dog was there. She did not agree to watch the dog. She told me she tried to contact Mr. Siak. He was not answering his phone. So she contacted his daughter and explained to her that she did not agree to watch the dog, did not want to watch the dog.
Did anything happen next?
The daughter began to yell and scream at her and told her that she'd be right back over to pick the dog up.
And what happened after that? What did Shelley Sage tell you happened after that?
She told me that Mr. Siak and his daughter arrived. His daughter came into the apartment and started whipping her. That's what Shelley told me.
And was that regarding Brianna Pett?
Correct.
And
Did you say whipping?
Whipping. That's what Shelley told me is whipping.
Could you repeat that? That she began, what was it?
Whipping.
Whipping her?
Yes.
And by that you mean Brianna began, in those words, whipping Shelley Sage?
Correct.
And then what happened? Or what did she say happened next?
Shelley told me that she removed herself from the doorway into the living room area of the apartment near the TV. And Mrs. Pat began to punch her. And that is when Shelley told me that Andrew was cheering her on.
And
As in cheering on his daughter of beating up Ms. Zajic.
did Andrew then do anything else?
Yes, that is when Andrew began on assaulting Ms. Zajic.
And how did she say he did that?
She told me he was punching her in the head, and then at one point got on top of her, mounted her, and put his hands around her neck, and he started choking her.
And did you ask, or did she tell you at all if she could breathe when he was choking her?
She told me she did not lose consciousness, but
She said what?
that she did not lose consciousness.
Did she describe that he put his hands around her neck?
Correct. And then I did observe when I first arrived at the apartment, red marks around her neck.
And what did she say happened next?
She told me that they left. They took both sets of her car keys to both her vehicles and her cell phone, so she could not contact the police regarding the matter.
And did she say to you, if Andrew see I did anything off that? If you recall.
No, not that I recall.
Did she tell you who Andrew Siak was to her?
At that point, they were boyfriend, girlfriend, dating on and off for approximately two months.
And did she say that to you that night?
Yes,
Did you take any photos that night?
I took multiple photographs of Ms. Davis' complete body, that she was bruised and battered up and burned across the majority of her body.
Burned?
Yes, sir.
And so you said burned. Did she happen to tell you why she was burned?
Yes, she did. I was asking her about her black eye, and she stated that the black eye was not from the night of the 22nd. It was from a previous incident. Ms. Vega told me, due to the numerous police calls we've got to the apartment, they were all real police calls. They were all in calls of help. But
I would object here. This is not cited utterance. This is pure hearsay.
Any response?
Your Honor, this, again, under MCL 768.27C, these statements are admissible so long as they happen to a law enforcement officer, and they are regarding a domestic violence incident. These are the statements that she said to him that night.
I mean, the statements have to be corroborated. Is your, I'm gonna admit it conditionally on you're bringing in Ms. Zajic, correct?
No, Your Honor,
You're not bringing in Ms. Zajic?
I cannot go.
She didn't show up?
She is scared. She is intoxicated.
And I expand my objection because this is the second time Ms. Zajac has been here. She's not present. Objection to this officer testifying. She was present 2 times and out unruly in the courthouse and had to be removed.
Your Honor, the statute does not, it is not how, the statute allows his statements, regardless of whether or not she is present.
Hang on a second. Was she subpoenaed here?
Correct, Your Honor.
She was subpoenaed and she showed up drunk?
Right.
But her availability does not weigh on whether or not this statute can be
Oh, I know, but it has to be corroborated, right?
corroborated, yes, and that corroborated by evidence other than statements that are admissible under only the section.
You're going into detail about prior incidents now.
Yes.
And
I understand what the statute says. I understand what the statute says. I want you to bring in this lady. Bring in Ms. Zajic right now.
you have to wait still here. Would you like me to excuse him for the time being, or?
No, bring her in. He's not going to say anything.
And if I may just.
Yeah, put her right in there. Ma'am, can you tell me your name? Can you tell me your name, ma'am? You're in a courtroom now, you know that?
Yes, yes, I do.
Tell me your name.
My name is Shelley.
Shelley what?
That's Sajan. Shelley Sajan.
Prosecutor tells me they subpoenaed you here today.
I don't receive mail, my mailbox.
Did somebody personally serve her with a subpoena?
We attempted to serve her personally. She didn't get it, but we were able to make contact with her. She was verbally served by Sergeant Driscoll. Then we had to go get her today.
She was picked up by officers this morning.
Oh boy, oh boy, oh boy. How can you serve something? There's only one way to serve a subpoena.
Exactly.
Ma'am, I didn't ask you for your input. I'm trying to figure out whether or not I should lock you up, because if you were subpoenaed and you show up in this state where it's impossible for you to testify, as far as I'm concerned, I'm gonna find that you've ignored a court order to appear. You couldn't even walk when you got it. So don't start playing lawyer with me. Oh, boy. You're in a bad way. You did not drive here, right?
No, Your Honor, she was police. Brought here by.
Right. But if they didn't properly subpoena, what are they doing picking her up and bringing her back? I mean, John, I'm just telling you, this stuff is going on now today. I just can't imagine. She is a mess.
I am a mess.
Ma'am, I don't need you to confirm that. I just observed it from my own eyes. Don't argue with me. They have to properly serve.
Your Honor, I can't tell you whether or not she was personally served.
He just all but told me that you verbally, Driscoll gave her the order or that's not proper service. I know you do. I'm not saying you didn't. They might have gone out there 89 times. She might have stayed in the house 89 times. I don't know. But you still have to have proper subpoenas. And you can't be picking people up without them being properly served. And if she's served with a subpoena and she shows up like this again, I'm going to lock her up for a week. And I'm going to make sure that she stays in jail where she can't drink, can't drug, can't start rendering opinions to judges. Why is this funny, Ms. Zajic? I'm not the least bit amused. Now, here's what I'm doing. I'm stopping this proceeding right now. I'm adjourning this 1 week. You can't just have officers come up here and reiterate things that happen. I mean, I know that this statute exists, and honestly,
It was a decision that we had to make given the circumstances.
I'm adjourning 1 week. She needs to be properly served.
Understood, Your Honor.
Adjourn 1 week. Mr. Siak, there were allegations that you had contact with her. Remember those?
Yes, I did.
Look, if I find out you have any contact with her, you will be sitting in jail as long as it takes for the cows to come home. We with one another?
Yes, sir.
Lisa, I don't know how I'm going to get through all these cases anymore. December 2nd, at what time? Ma'am, if you're subpoenaed and you show up like this again, I'm telling you, you are going to have you're not going to like what I'm going to do. We're adjourning the preliminary exam. I don't even know when I can do it next week. You give me a time, Lisa?
December 2nd at 11.
At 11. Okay, good enough. That's what we're doing. December 2nd at 11. Thank you. You can step down. You're gonna have to be here too. Thank you. Do we ever have this gentleman at the MDOC?
No, I tried to call, but I had to leave a message.
Judge, this is Attorney Sterling Coleman.
I know. You guys got to show up. I got these prisoners at 10 o'clock. I don't know when they're showing up. People against. Listen,
yes.
Let me call the case. Carry on Quandel Nathaniel Miller, 25B7169042. I can't figure out if I'm just getting cantankerous or lawyers.
It was
are
set
just
for 11.
overbooking. They're just, what's that?
It was
They're
set for
over.
11, Judge, not 10.
Okay. Is Mr. Arnold out there? Or Mr.
No,
Mr. Miller?
Mr. Miller?
He's in the MDOC. He should be on Zoom.
They have not logged in yet.
They haven't logged in.
I called
so Judge,
and left it.
if I'm the judge, I want to resolve this today.
Well, I can't resolve it if he doesn't show up. You know that. I'd love for you to resolve it today, but I can't let you plead for him
I get it. So what I'd like to do is come back right after lunch.
Fine. Can
Judge,
wait a minute.
No, I've tried to contact them and they haven't responded back yet.
So
I don't know
here's
that I
what
can
I'll
get
do,
them here.
Mr. Coleman. Listen, we don't control these departments and Department of Corrections and the jails, and we're basically at their mercy. But she will. Can you email them, Lisa, or do you call?
I tried both. I haven't had a response yet.
Why don't you tell them to come
They
in
might
here?
just be backed up.
What's that?
They might just be backed up.
Right. So what do you want to do? Because I think all of us deserve a lunch after this interesting morning. And I'm going to tell Mr. Coleman, unless you have a different idea, for him to come back at about 1:15 and check in. If you got
Can I do about 2 o'clock?
We still have 4 cases at 1 o'clock. So would it be easier to just adjourn it to next week?
No, I'd rather do it today. I've already heard that next week is going to be, and I've got a wife who will be in surgery next Monday. So if I can do it at 2 o'clock.
Well, we weren't going to do it on the 2nd. We were going to do the exam on the 9th. Listen, we're not trying to fight with you here, Mr. Coleman. I gave you that extra week, if you'll remember, but we don't control them. So.
Yeah, I know. I got a resolution. I got a plea.
Mr. Muhammad, you going to be here?
Next week?
No, today. You going to be here this afternoon?
Yes, I have one more hearing at 1 p.m. It's a PCC.
Good. Well, why don't you come back here at 1:30? How's that? And we might have to tell you we're adjourning it to the 9th. I don't want to. But sometimes MDOC and these other facilities, they just don't get the people on there quick enough, and we end up battling between when the lawyers are available and the defendants are available. And then the jail gets mad at us, thinking the judge is in the back.
I'm sorry.
So that's what we'll do. Come on back at 1:30. Let's see what we can do. Okay.
Thank you, Judge. Thank you.
All right. Thanks. And you have to stay until that's done. Okay.
And in that investigation of that individual, they found a video on that individual's phone that had been produced in his basement with an individual on a video who resembles Mr. Allen Dabney sexually assaulting a child. Through that, they got his phone for this investigation and located an overwhelming amount of CSAM on his device.
On Mr.
Yes, and those images include images of children performing sex acts on each other, as well as being sexually assaulted by adults, as well as nude photos. And the report only just gives a small, preview of that. The report states overwhelming amount of CSAM on his device. So I have extreme concerns given that he was investigated for a video of him sexually assaulting a child, which then led to.
You understand now I'll hold on. She just indicated
you need to not interrupt.
Okay.
She did not interrupt you.
She just
No, what did I say?
I understand, Judge.
Go ahead, miss.
And then now they find all these other images and videos on his phone. So I have concerns with asset bond remain as set.
What I would like to object to was she indicated it resembles. They had 9 months to determine whether or not this was in fact that a person on the video. And now she's saying resembles, and then 2 minutes later, she said, it is him? I object to that mischaracterization, Judge.
And it was led to him, and then there's CSAM on his phone.
And just as I know it may not matter, but Mr. Allen Dabney was involved with this man in a romantic relationship, and this man that they found the devices, he had possession of his devices, of my client's devices. Sharik Alam, this person stayed in Canton. The authorities was led to this other individual's location. My client was involved romantically with this person that they arrested and charged back in Canton in February. As I already indicated, I understand that the charges are serious, but what I really do not like is that when she says resembles, that means that they don't know if it's him or not. And for the fans,
maybe that's the purpose of these proceedings.
I understand, but I don't like the fact that she said resembles and then says it's him.
That led to him, as I'm to understand, and that.
Yes, I'll correct what I said. If the report says resembles, we have to talk with Detective Morrison further to see what that video actually entailed, as it was just the first part of the report. So I'll correct what I originally stated. But that video did lead to them getting Mr. Allen Dabney's phone and locating voluminous amounts of CSAM on his device.
Anything further?
No, Judge. I just think that a more reasonable bond in this circumstance with no prior criminal history would be more like 100,000, 10%, Your Honor.
Well, given that if it was that individual, but then led to CSAM, which was on his device,
which was in the possession of his lover.
You want to? I'll let you go.
Oh, I'm sorry.
No, I'll let you go.
I don't have my robe on today.
I know you don't have one at all. And maybe you got to figure out who does.
I understand. I'm sorry. Get a little excited.
Because this is going to be a long hearing.
No disrespect, Judge.
Well, it was.
Okay.
Given everything that the court has heard, and further that there are additional charges, which I understand are coming in the case, the court does believe that the bond as set is appropriate. Motion for bond reduction is denied. Bond will continue.
Thank you.
Your Honor, just briefly, may I just respectfully ask for 10% or no?
Bond will continue as set. Thank you.
Thank you.
Happy Thanksgiving. Happy Thanksgiving. Remember, Thanksgiving. Here.
Oh, yes. Is that supposed to help? Hold on. Nope, doing nothing. Let's see what this does. Court calls case People versus Gavin Porter.
Another order, assistant prosecuting attorney to the people.
Good morning, Your Honor. Paul Taylor appearing for defendant Gavin Albert Porter, who is standing at my right.
Your name, sir?
Gavin Porter, Your Honor.
I have before me a plea form that indicates, is that what we're doing?
Yes. Yes, Your Honor.
Plea form indicates that the defendant would be pleading guilty to the charge of illegal transport of a firearm in a vehicle, the 90-day offense. Upon a successful plea to that charge, count one would be dismissed. There's further the agreement that the prosecutor will recommend a sentence of no additional upfront jail, and the sentencing judge waiver is, that's the court's full understanding of the agreement.
That's correct.
That's our understanding.
Trying to get me with not transporting, but unauthorized.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Gavin Porter.
Thank you. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of illegal transport of a firearm in or upon a vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that, sir?
Yes, Your Honor.
All right. Still, and you also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty?
Yes, Your Honor.
On the date of September 19, 2025, at the location of 1620 East Medical Center Drive, City of Ann Arbor, Washtenaw County, State of Michigan, were you in a motor vehicle? Were you in a Chevy Silverado?
I own a Chevy Silverado. Yes, Your Honor.
I'm sorry to hear that, but were you in it? I'm a Ford guy, so I had to say it, but
I had my car valeted.
Pardon?
I had my car valeted that day. That was it was in the possession of the valet.
Okay. And in that vehicle, at some point you drove to the valet.
Yes, Your Honor.
Correct. All right. And in that vehicle, was there a pistol?
Yes, Your Honor.
And where was it located?
In my center console, Your Honor.
All right. And do you have authority to transport that weapon in that fashion?
No, Your Honor.
All right.
Not yet, Your Honor.
Pardon?
Not yet, anyways. I'm trying to get a class on.
Got it. Okay. But at the time you did not.
I did not.
All right. Sir, if I accept your plea, in this case, court does have to advise you if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, the court would no longer be bound by any recommendation or evaluation in your case, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People are not, Your Honor.
No, Your Honor, we are not.
And has the court complied with the court rule, and would it be proper to accept this defendant?
People are satisfied, Your Honor.
Defendant is satisfied, Your Honor.
All right, court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
December 19th at 8:30 a.m.
Your Honor, if we may, could it please be pushed into January?
The court over there will be more than happy to do that, I think.
Okay.
Okay, that's the only date I have.
Yes.
That's the only date I have.
Okay. Thank you, Your Honor.
December 19th, 2025. What time?
8:30.
At 8:30. Bond in this matter will continue unless you want to make an argument. No, go ahead.
Thank you very much.
Thank you, sir. Have a good holiday.
Happy Thanksgiving.
Court does call the case. People versus Devon Galliard.
Hey, Alexander, on behalf of people.
And good morning, Your Honor. Attorney Maxwell Dubin, P number 86012, on behalf of Mr. Gilliard.
Sir, can you state your name?
Devon Gilliard.
Thank you. All right, what are we doing in this case?
Your Honor, today's the date and time set for PCC. I'm asking for an adjournment of the PCC, and then if I'm able to address bond, Your Honor.
Yeah. You want I can do December 4th or the 11th. He's in custody, so I'm going to go to the 4th. Okay. Probable cause conference, December 4th, 2025, 9 a.m. Esteban.
Your Honor, I believe this court may recall this case. At the last hearing, you revoked bond. My client was intending to, or was granted previously to go to Texas. He did not go to Texas. He returned to Georgia, subsequently revoking bond to a no bond warrant. I want this court to know first and foremost that my client is not here to make any excuses, reasons. He understands that when a court puts in an order, that order must be followed to a T. It doesn't matter what mistakes you make or what you think. Everything needs to be, every I needs to be dotted and every T needs to be crossed. Okay, Your Honor, that being said, I would point out that my client does not have a history, a criminal history whatsoever, pretty much and he's never been on a tether prior to this. He did make a mistake. He is owning up to that, Your Honor. What I'm asking here today is that this court either allow him a second chance to prove himself, and in the alternative, give him some type of attainable cash bond. When you did revoke bond, I know it's obviously court ordered. I will point out that my client immediately drove from Georgia, made arrangements, and turned himself in immediately, showing that he can abide by any rule sanction that this court puts upon him. Just to give some clarity, not as an excuse, the reason he did not return to Texas, Your Honor, is my client was in the military.
I lost you, counsel. I can't hear you.
Can you hear me now, Your Honor?
I can.
Which part did you lose me at?
I don't know because I didn't hear it.
Okay. Well, okay. Well, in short, Your Honor, just some background. Besides, my client does not have a criminal history. This is his first time dealing with something like this. He did not return to Texas, and this is not an excuse. He did not return to Texas. His intention was to. That being said, the military, which he was in prior, actually shipped his stuff to Georgia, to his mother's house. That was the reason he did go to Georgia and went to Georgia. What we're asking here today is an attainable cash bond and or a second chance to prove to you that he can abide by any rule sanction that you would put upon him, Your Honor.
Any response from the people?
Your Honor, at this point, I'm going to object. I don't know. I have concerns. I don't know exactly where he would be staying if he's released. I have concerns that he was given the chance to go to Texas. He told the court and people he was going to Texas. He didn't go to Texas. He went to North Carolina, South Carolina, Georgia, never went to Texas. And I have concerns that if he's released, he's just going to go wherever he wants. And he said last time during the hearing, he thought since he's on the tether, he could just go wherever he wanted. And then I have concerns given that he went to Georgia, and the argument was that if something came up for court, like an exam or a hearing, he had to attend in person, he would be there in person. He wasn't here last time in person. He was in Zoom. The only way we got him here in person was that he had to turn himself in on a no bond warrant. So I have concerns that this time I don't have enough information on where he'll be staying, what those terms of bond will look like when he gets out, because I don't know if he's going to try to go back to Georgia or if he's going to try to go back to Texas. I just don't know. So at this point, I'm going to object.
Anything else?
Yeah, if I may respond briefly, Your Honor, if my client is given bond, he will stay and remain in Georgia and even come back in person.
How do I know that?
Well, if I may,
mean, because the last time he told me he was going to reside in Texas, and I let him leave, and he never set foot in Texas.
And if I may just respond to how you would know that, Your Honor, besides the fact that he's on tether, he was very upfront with the tether, with probation. He didn't lie. He didn't try to say he was in Texas when he wasn't. He was very candid with them when they asked. And he knew he was being tracked and monitored. So his intention was not to deceive you in any way. But that being said, I and my client understands why the court did what they did in revoking his bond. I want this court to understand that my client is attempting to be very candid and upfront. He's not running away. And the reason, if I may respond to the prosecutor, that he appeared via Zoom is because he couldn't get here in time. So I had him log on because he didn't want to not appear at all. And then, of course, subsequently his bond was revoked and he immediately came back. He's not running from this, Your Honor.
At this point, the defendant's bond will continue as revoked. I let him leave. He told me where he was going. He's now trying to, and never went there. And now he's trying to tell me he's going to some other place. I have no idea. I can't believe this defendant. I can't trust that he's going to do what he says he's going to do. So the motion for bond reduction or bond in this case is denied. This matter is adjourned to December 4th. Thank you.
Thank you for hearing me out, Your Honor. And I hope you have a good rest of your day as always.
You do the same, sir. Well, look what the cat drug in. That's why stuff started out wrong. Childers was around in the building. I felt something. That's why my day is starting. Mr. Childers, how are you, sir?
Well, Judge, thank you for asking.
And your family is doing well?
Very, very well.
I'm glad to hear that. And welcome back.
Good to be back.
I'm happy to have you back. These people have been out of control. No, it's been really bad. We'll talk. Anyway, court does call the case of the people versus Zipporah Morgan.
And the water system prosecuting attorney.
Good morning, Your Honor. Jonathan Sachs for Ms. Morgan, who is appearing via Zoom from Georgia. Supposed to be.
Is she really?
Yep. Ms. Morgan.
Did you see that last guy there? No kidding. Don't answer. Anyway. State your name, ma'am.
Zipporah Morgan.
Thank you. I have before me a plea form. Is that what we're doing?
It is, Your Honor. We have a negotiated plea worked out for a deferred sentence and a misdemeanor disposition.
The plea form indicates that the defendant will be pleading guilty to the charge of improper possession of a firearm in or upon a vehicle. The 90-day offense. Upon her successful plea to that charge, count one would be dismissed. There is a sentence agreement of a deferred sentence pursuant to 771.1. That's the court's full understanding of the agreement.
That is correct.
That's correct, Your Honor. Thank you.
Ma'am, can you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name for the record, please. You muted.
Oh,
State
Zipporah
your name.
Morgan.
All right. You can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of improper possession of a firearm in or upon a motor vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court cost, and mandatory forfeiture of the weapon or device. You understand that?
Yes, sir.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed gave permission to sign a advice of rights form. Is that correct?
Yes, sir.
Do you have any questions regarding any of the rights on that form?
No.
With particular attention to paragraph 5, those are your trial rights. You understand that you're waiving or giving up all of the rights that are contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
On October 26, 2025, at the location of 579 Eugene Street in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle or in a motor vehicle?
I was getting out of a motor vehicle, yes.
And in that motor vehicle, or while you were getting out on your person, was there a firearm?
Yes.
Was it yours?
Yes, sir.
And where was it located?
In the middle console of my car.
All right. Did you have authority to carry that weapon in that fashion?
No, I did not.
All right. Ma'am, if I accept your plea and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, I do have to advise you that the court would no longer be bound by any evaluation or recommendation regarding your sentence, and you would not be entitled to withdraw your plea. You understand all of that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
I am not, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be
January 15th at 10 a.m.
January 15th, 2025, 10 a.m. That is before Judge Washington. Bond in this matter will continue. Happy Thanksgiving. Thank you.
Thank you. Sorry, you too.
Happy Thanksgiving, Your Honor, to you and the court, to the prosecutors, and especially the public defenders.
Anybody else you want to bring into that? And happy Thanksgiving to you, counsel. Court does call the case, People versus Robert Barnett.
Yes, call this people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Barnett. State your name for the record, please, sir.
Robert Barnett. Next time, Perry, when they won't let you do it, just push it.
I think Your Honor has a couple documents in front of you. There's a exam waiver on both cases.
There is.
And I would ask Ms. Feltus to put the agreement on the record. And there's also an order for release to treatment. I think at Mr. Barnett's previous hearing, Your Honor stated that he could be released to treatment. I don't think an order ever made its way to the court. So that is why I have submitted that today.
All right, very good. And just to clarify that order, and then I'll let you put everything on that order without a GPS.
I can add that if the people in the court want.
I would like that.
Yeah, typically, so that you're aware, I typically require that unless there's some reason the facility won't allow that.
Would you like me to add it and resubmit?
Yes, please. All right, and then I would sign off on that.
Part of the offer that was extended to the defendant was if he did waive the exam, he would have the opportunity in circuit court to plead case 24F20965, which is the stolen vehicle case, and dismiss 25F55793 case, which is the drug possession case. There are no other agreements.
Got it. And counsel, just so that, because at the point I'm going to lose jurisdiction, so you may want to just write it on here and submit it to the court today.
Okay.
Okay. So you're waiving your right to hold a preliminary examination?
Yes, sir.
You understand the preliminary examination is a proceeding by which people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes.
People waive their right to a preliminary examination in both cases?
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on the single count in each case.
Your Honor, we acknowledge receipt, waive formal reading, and stand mute, please.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial will be set for
December 18th at 1:30 with Judge Slay.
December 18th, 2025, 1:30, Judge Slay.
And I think the court wanted me to add that GPS tether provision to the
one you submitted.
This is the waiver form.
Oh. Gave her back the one she did right. Is that?
No, you haven't. 1 for 2 is not bad.
December 23rd, 2025.
December 18th.
December 18th. What did I say?
23rd.
That's because she kept messing me up. December 18th, 2025, 1:30 before Judge Slay. Bond in these matters will continue.
Okay.
Thank you. Listen, I don't know where. Court does call the case People versus Martina Smith.
Water Assistant Prosecuting Attorney for the People.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Ms. Smith, who is present and approaching to my right.
Morning.
Morning, Mr. All right. What are we doing?
Your Honor, we are asking that this court set this matter out for a preliminary examination. I'm asking for some additional time though I do have all discovery, there's a issue I need to follow up on, and it may lead to a better resolution for my client.
But as for the discovery you have from the people, you have that now.
Yes, what I need to follow up is not in possession of the government.
Got it. And how much more time, sir, would you need?
Probably a week, y'all, extra week.
Setting these for the 9th, correct?
Yes.
I would be setting these for the 9th, so I've got the 16th, 23rd.
I'd ask for the 23rd. The 9th, I'm in a homicide trial in Ingham County.
23rd.
Yes, sir, please.
People have their witnesses available the 23rd.
We'll do our best.
Preliminary examination in person, December 23rd, 2025, 12 noon. That's before me. Bond. You'll continue. Thank you. Is that it for you, sir?
Yes, sir, it is, Your Honor. Thank you.
Please, on a separate matter.
Your Honor, is that before this court?
Yes, before me. Mr. Jones, you can approach, please, on a separate matter.
Good morning. Can you state your name, please?
Michelle Campbell.
Thank you.
Judge, I met with Ms. Campbell yesterday at the jail. We're asking for an adjournment to see if we can try to work out a global resolution of all of our matters pending in this county.
All right. Will December 4th give you enough time to do that?
I hope so. We'll try.
Okay. Probable cause conference will be adjourned December 4th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Court calls case People versus Julia Abiano.
Good morning, Your Honor. Corey Silverstein appearing on behalf of the defendant.
Abiano, can you state your name, please? Probably need
Julia
to unmute.
Labiano.
There we go. Thank you. What are we doing?
Good morning, Judge. Your Honor, this is a case that has a mental health element to it. Originally, what we had discussed doing was we were going to do a referral to the mental health court, but unfortunately, Ms. Labiano can't establish residency in Washtenaw County right now, which has caused a little bit of a hiccup. So I do need to speak with the prosecutor again. I'm not sure which prosecutor it is, because the last time we were with you in person, you had the deputy prosecutor was in your courtroom and we were working with her. I don't know who's handling the case now.
All right. She's not a resident in Washtenaw? Is that the issue?
That's the issue, Your Honor. What we were trying to do was, I was talking to your court clerk, and they were talking to mental health, and we were trying to see if there was a way we could make it work, because this is an individual who could truly benefit from the program, but unfortunately, we just haven't been able to get her a physical address in Washtenaw County that would work. So it seems like me and the prosecutor still have some work to do here. Like I said to you before, I'm not quite sure which prosecutor is handling the case.
I'm the prosecutor assigned to it now, so you can reach out to the office and ask to speak to Kenneth Overwater, and we can discuss that.
Oh, fantastic. Could you give me your last name one more time? Forgive me, it was a little hard to hear.
Overwater.
Fantastic.
Yep, so this matter out to December 18th, 2025, 9 a.m.
There is another issue. I'm not sure exactly when this happened, but Ms. Laviano has been charged with a misdemeanor domestic violence charge. She's not yet been arraigned on that, and there is a warrant outstanding on it.
We,
Out of what jurisdiction?
That would be, I believe, 15th District Court.
Okay, we're not gonna have the complaint. You heard that, counsel?
I did, Your Honor, and this actually was an incident that predated this one. So what we're doing is we're making arrangements. I've already spoken to the 15th District. We're working on making arrangements to get that bench warrant cleared up.
Good. December 18, 2025, 9 a.m. bond in this matter will continue. Thank you.
Your Honor, does the court have any issue with us appearing again on the 18th by Zoom?
If you submit the forms, we'll consider it.
Sounds perfect. Thanks, Judge.
Court calls case People versus Rontrell Davis.
Ashley Feltus for the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Rontrell Davis. Mr. Davis, state your name.
Rontrell Davis.
Your Honor, we are asking to adjourn this for, we're waiting on media discovery for a court date before December 18th, if possible.
Pardon?
Is it possible to set the next court date before December 18th? He has another court date then.
Sure. Will the 4th work?
I believe so, yeah.
Cause conference, December 4th, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Javante Poplar.
Senator Water, Assistant Prosecuting Attorney for the people.
Sherilyn Foster Tucker on behalf of Javante Poplar, who should be on the Zoom.
Oh, there he is. State your name, sir.
Javante Poplar.
All right.
And Your Honor, we're requesting an exam in this matter.
We're on the 9th, is that right?
Yes.
Discovery is complete.
To my knowledge.
People have their witnesses available the 9th.
I expect Michelle.
Preliminary examination in person, December 9th, 2025, 9 a.m. That's before
Judge Val.
Judge Valvo.
Is that still in the same courtroom, Your Honor?
Pardon?
Is that still the same courtroom?
Same courthouse.
Oh, yeah, courthouse. Yeah. Okay. Thank you.
Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Matthew Melzo.
Senator Water, Assistant Prosecuting Attorney for the people.
Assistant Public Defender Natalie on behalf of Mr. Melzo, who is approaching. Please state your name for the record, sir.
Matthew Melton.
Thank you. You're requesting an adjournment.
Yes, Your Honor. There is some still outstanding media discovery that hopefully I will get soon. So I'm asking for an adjournment of the probable cause conference to make sure.
The matter will be adjourned December 4th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continues. Thank you. Court calls the case People versus Earl Williams.
Senator Water, Assistant Prosecuting Attorney for the people.
Sherilyn Foster Tucker on behalf of Earl Williams.
Your name? Earl Williams. All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates the defendant will be pleading to an added count 2 of false pretenses, 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There's a sentence agreement of a sentence under the Home to Fill Trainee Act. That is the court's full understanding of the agreement. Is that correct?
That is correct, Your Honor.
That is correct, Your Honor.
May I have him sworn?
Right hand. Do you solemnly swear in the affirmative testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Earl Williams. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of false pretenses, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The court would further have to advise you that the fine can be increased to 3 times the value of the property, which is the subject matter of the crime. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court. Yes, sir. Still wish to plead guilty? Yes, sir. And to that charge, how do you plead? Guilty. Now, you understand that by pleading guilty, you will not have a trial of any kind? Sir. You signed an advice of rights form, is that correct? Sir. Any question regarding any of those rights? Sir. Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes, sir. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? No, sir. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No, sir. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily and of your own free will? Yes, sir. And also because you believe that you are indeed guilty of this offense? Wait, can you repeat that for me? You're also pleading guilty because you believe that you're guilty of this offense?
Do you believe you're guilty of this offense?
Oh, yes, sir. Yes, sir. October 11th, 2025, at the location of, well, I don't really have a location. The city of Chelsea, Washington County, state of Michigan. What do you do that makes you think that you're guilty? Use counterfeit money to purchase stuff at stores. All right. So you had money that you knew was counterfeit? Yes, sir. And you used that money to purchase items at various places? Yes, sir. All right. The amount of these purchases or the amount of counterfeit bills that you intended on passing or bought those items with, was it more than $200? No, sir.
What's the amount of money that you got back?
Or like 50. Pardon? Probably like 50. So you only used $50 of counterfeit bills? No, I used probably like around 300. Which is a bigger number than 2, right? Yes, sir. Yeah, okay. All right. Maybe not in counterfeit, I don't know. All right. And so, and your intent was to mislead these various places and or businesses that the monies that you were giving them was real. Is that correct? Sure. Sir, I do have to advise you that if between the time of my taking your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any recommendation or sentence evaluation, and you would not be entitled to withdraw your plea. You understand that, sir? Yes, sir. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be January 5th, 2026, 9 a.m. That's before Judge Fresh Hour. Bond will continue.
And Your Honor, if I may just address bond briefly, Mr. Williams is on a GPS tether. I don't believe that there have been any violations of that tether that I've been made aware of, and he has appeared for all of his court dates. He asked that the court considers removing the GPS tether.
Any response from people? Not that I need one. I don't need a response. Motion is denied. I'm going to continue to tether.
Thank you, Your Honor.
I think she's court does call the case People versus Alan Rogers.
Sandra White on behalf of Alan Rogers.
Your name, sir?
Alan Rogers.
Thank you.
Your Honor, I'm asking for an adjournment for further negotiations with the prosecutor.
Probable cause conference will be adjourned December 4th, 2025. And bond in this matter will continue. Thank you. Court calls case People versus Joel Serbinoff.
On behalf of Mr. Serbinoff, who's appearing by Zoom.
Servanoff, please unmute yourself, turn on your camera, state your name for the court.
Joel Servanoff.
Judge, today is the date and time set for probable cause conference. We are working on an offer, trying to get Mr. Servanoff into treatment court. So we are asking for an adjournment at this time.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond will continue.
Thank you, Judge. You're free to.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Kevin Smith.
For the people.
Good morning, Your Honor. Assistant Public Defender Davi Leva for Mr. Smith, who stands to my right. Mr. Smith, could you please tell the court your name, sir?
Kevin LeBarn Smith. What are we doing?
I'm going to like to request an adjournment, and I'd also like to address bond, please.
December 4th, 2025, 9 a.m. as to bond.
Thank you, Your Honor. So I just talked to Mr. Smith yesterday. He tells me that he's suffering from bipolar schizophrenia and does need medication for that. He could stay with his mother if released. We would have no objection to a home confinement tether to ensure his appearance at court, which I believe was the reason for his remand. I would note this is a non-violent case where the allegations are simply theft of books from a library. And I do believe that a tether would ameliorate any concerns regarding the previous failure to appear.
Response.
Yes, as Defense Counsel stated, the previous failure to appear. I believe we were looking at mental health treatment court for this person. That was the goal of the people, was to get him into that specialty court so we could have the support necessary. Concern anything at this time before he's trained in the treatment court would not set him up for success. I would ask that the court continue the bond, train the next 10 days, and we'll be able to.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Antoine Thomas. Sir, you got to keep moving.
Ashley Phelps for the people.
Carbadell on behalf of Mr. Thomas, who's approaching the podium, will be standing to my right. Mr. Thomas, when you go up here, please state your name for the record.
Antoine D'Angelo Thomas.
Thank you. Take your hands out of your pockets, please.
Your Honor, today is the date and time set for probable cause conference. Again, similar to my last case, we are working on getting Mr. Thomas involved in treatment court. So we are asking that for a brief adjournment at this time. It is out county, so a bit of an extended.
December 11th, 2025, 9 a.m. Bond continue.
All right.
Court calls case of the People versus Bonnie St. John.
Ashley Phelps for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. St. John. Ms. St. John, state your name for the record.
St. John.
Thank you.
Your Honor, we are asking for an adjournment of the PCC for negotiations, and I would like to address bond.
Probable cause conference will be adjourned to December 4th, 2025, 9 a.m. as to bond.
Your Honor, Ms. St. John is requesting a personal bond. She has a number of reasons why she would like to go home. The most important is her medical conditions. She has Parkinson's that is worsening daily. She is on a number of medications for that. She also has diabetes, significant pain that she deals with, and she's also undergoing testing for potential cancer. Those things are obviously hard to do in the jail. And so Ms. St. John would like you to take that into consideration. This case is a drug case. She has set up treatment at Gretchen's place in Belleville. She was about to go there when she was picked up on this warrant. So if
that before or after her use of cocaine?
I believe that was after. She organized that treatment. So if she were to be released, she would be attending classes there. She's also engaged in therapy, I believe. Yeah. If she were to be released, she would go home to her husband, who helps care for her. They're both retired. I think Ms. St. John did have a failure to appear. I think she had, she didn't go to community corrections within a certain amount of time. From talks with her husband
Well,
and her,
and she went to community corrections, tested positive twice for cocaine use.
yes, from the talks with her husband, apparently her memory from the Parkinson's is significantly affected. So knowing that moving forward, we'll make, other efforts to get in touch with Miss St. John to remind her of everything she needs to do while out on bond.
Don't need a response with all of that, and considering everything, and defendant's continued use of narcotics in violation of bond. Motion for bond reduction denied. Bond will continue. Court calls case People versus, is it Micah Williams?
Hi. To Micah.
Prosecuting attorney People.
Robert, on behalf of Ms. Williams. Ms. Williams, please state your name for the record.
Micah Williams.
Thank you.
Judge, today is the date and time set for probable cause conference. We are asking for an adjournment at the time. The court should be in receipt of the green sheet.
Probable cause conference, December 4th, 2025, 9 a.m.
December 4th, you said, Judge?
Yes.
Thank you.
Bond continued.
All right.
Thank you, Ms. Williams.
We'll be in touch.
Okay.
Court calls case People versus Picopio Vitale.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Vitale, who's here to my right.
What are we doing?
Your Honor, we're seeking a very brief adjournment. Mr. Vitale has cleared the first hurdle to the drug court. They are coming, it's my understanding they're coming to interview him personally at the jail in the next few days.
Few days.
Yes, yeah, I mean, they said this week, but it's a short week, so I would bet early next week, Judge.
You think everything will be accomplished by the 4th, or?
Maybe we should do the 11th just to be sure.
Be sure.
I think he sees Judge Slate for some reason, oddly on the 5th. I don't know why, but.
Okay. All right. I'll adjourn both of these to December 11th, 2025, 9 a.m.
Thank you, Your Honor.
Court calls case People versus Deveron Anderson.
Assistant prosecuting attorney for the People.
Case. Geos.
Sorry to help you.
Do we have the defendant in Zoom now?
Both of them.
Okay.
Sorry, Your Honor, Assistant Public Defender Chelsea Vergils with and on behalf of Ron Anderson, please state your name.
Deveron Anderson. You're getting more and more like I can really.
I'm sorry, Your Honor.
Yeah. Wow. Wow. What's wrong?
Sorry.
I know, because she knows how much that would irritate. She's doing the right thing. She's good.
I'm doing my best, Your Honor. Thank you for your patience. In this case, we'd just like to set a preliminary exam.
Discovery is complete.
To the best of my knowledge, it is, Your Honor.
People have their witnesses available tonight.
I believe so.
Preliminary examination in person, December 9th, 2025 at 9 a.m. before Judge Washington. Bond will continue. Thank you.
Thank you, Your Honor.
Mr. Bowling and I approached on an urgent matter.
Yes, you may.
Hold on, we'll see you again once.
Warren, Assistant Prosecuting Attorney for the People.
Good morning, Judge. Christopher Quinn, appearing on behalf of Mr. Davis.
Your name?
Aaron Davis.
All right, what are we doing?
Do you have a resolution in this matter? I should prepare a plea form. I can print that, give it to counsel, and we can do it today, or we could get it another day, whatever the court does.
We just did it. Where is it?
I would need to print it.
Okay.
Thank you.
Court calls the case People versus Rick Artuso.
Senator Water, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Natalie. Who's approaching? Please say your name for the record, sir.
Rick Artuso.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. We are respectfully requesting an adjournment. I did get some updated contact information from my client this morning.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond continued. Thank you.
Very much, Your Honor.
Court calls case People versus Larry Atkins.
Brian Bowley on behalf of Mr. Atkins, Your Honor.
Larry,
just state.
dang, I said last time, I said, I'm going to get it right. I'm going to get it right. I committed it to memory. I just left.
Larry Atkins.
I don't think that's his name. I'm gonna sign an order changing it. That way I'll be right. All right.
Judge, we have a resolution. There's
Yes.
a plea form before you and also an assigned advice of rights.
All right. The plea form indicates that the defendant will be pleading guilty to the charge of false report of a misdemeanor to 93-day offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of it. Is that correct, counsel?
That's correct.
May I have him sworn?
Raise your right hand. Do you solemnly swear in front of the testimony about to give the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
State your name.
Larry Atkins.
Sir, it is this court's understanding you're going to plead guilty to a misdemeanor charge of false report of a misdemeanor. That is itself a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that, sir?
Yes.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B district.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Which one?
Probation.
You're on probation. Were you on probation at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record?
Here and let them know that I was out on ankle monitor and that I needed some type of proof to present to Judge Judy Goodman, so I can come up here. And I had talked to Mr. I forget his name, but I talked to him and he told me that he will issue out a warrant for arrest because I can't make it up here because due to the ankle monitor, and they was not letting me the pre-trial down in Lexington.
Okay. You're getting way ahead of yourself.
I apologize.
We got to deal with the counsel first thing, because everything's being recorded right now, so everything you say can be used against you if you decide that later you want to have a hearing. So let's stop there.
Yeah.
You don't want to have an attorney?
No.
Okay, Mr. Laux is going to hand you a form. It's just a waiver of counsel. You're giving up a very valuable right that you need to make sure that you understand what you're doing.
Yes, I do. So much. Like I said.
All right, just
Yes,
take
sir.
a breath and relax. Okay, let me do what I got to do up here. Okay, sir?
Yes, sir.
All right, Mr. Reese, that's your signature?
Yes, sir.
Did anybody promise you anything or threaten you in any way to get you to waive your right to counsel?
No, sir.
Are you under the influence today of any drugs or alcohol?
No, sir.
All right, the court's going to make a finding then that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and I will accept that. Now, with regard to what the officer said, the allegation, do you want to have a hearing, or do you admit to what he said?
I admit to what he said.
Okay.
I actually just.
All right, now, tell me what you want me to know.
Yes, as soon as I left from here, I tried to expeditiously get the signature done before Lexington picked me up. They actually came to grab me December 23rd. And when I got down there, I got released January 3rd of 2025. And as soon as I got out, I had to go report to pretrial and report to a court date down there. And as soon as I did that, and I called up here to let everybody know that I wouldn't be able to make it because I asked Mrs. Goodman and I asked pretrial, can I come? And they said, no, we need proof or some type of schedule so it can go before the judge, go before the courts, and I will allow you to go. I haven't even been able to come to Ohio for my medical situation. I've been going to emergency room after emergency room in Kentucky to just to get some medicine. Now, I did fail the THC because I ate edibles because of my chronic seizures, and I know that's not a big thing with you, and I apologize, but that's not my thing, and I don't want to continue doing it. I'm trying to get in school. I'm actually applying for HVAC, stuff that I can do while I'm sitting on the box. I've been on the box for 10 months. I haven't caught any new charges. I don't do anything. I do everything I'm supposed to do.
Okay, you live in Kentucky.
Yes, sir.
So, right, so what we're going to do today is, and I understand the confusion in some of this, you understand the rules now?
Yes, sir. And I just signed it.
You've already signed the ICOS transfer?
Yes, Your Honor. His story is accurate. It's a simple fact of after his sentencing, he was expedited down to Kentucky, and we were never able to get rules signed or an ICOTS application signed. And with us not being able to get him back in office, a warrant had to be filed.
Okay. All right, so what I'm going to do, Mr. Reese, is despite this violation, I'm going to continue you on community control under the same rules and conditions that I'd previously set forth. Need to stay in contact with the Sukavecki, Officer Sukavecki. Make sure you stay in contact with her, okay?
Yes, sir.
And I do not allow the use of marijuana.
Yes, sir.
Listen, if you are going to be working, your employer is probably going to drug test you.
Yes, sir.
I have one of my veterans that I stopped smoking marijuana after 35 years.
Yes, sir.
And he's got his CDL now, and I told him, I said, the problem is if you get stopped, those the THC metabolites stay in your system for weeks or perhaps even months, what could put you over the legal limit for driving or operating machinery or working. So I mean, if you're going to do these things, don't risk it by continuing to use marijuana, because it's still illegal federally, and a lot of jobs just don't allow you to use it. So I'm trying to help you here. Don't get hooked on it, okay?
Yes, sir. I appreciate you, Mr. Tepe, and like I said, I'm working on. I've been turning my life around, getting in school. I just completed the GED course, and I'm applying for HVAC. I start in the beginning of January.
Okay, all right.
I just missed an appointment so I can come over here and do get my medicine. Mrs. Goodman, she's been working with me and whatnot, so I have been doing what I'm supposed to do, and I just felt like, all right, the time is now to go ahead and turn myself in and take care of this.
All right, very good. All right, you'll be released today.
Thank you, sir.
All right, thank you. Najee Howard.
Good afternoon, Mr.
Hello, this is case number 22CR38882, the State of Ohio versus Najee Howard. Mr. Howard, the court has received a report that alleges that you have violated the terms of your community control. Officer, statement, please, of that allegation.
Yes, Your Honor. Under general condition number 5, on September the 12th of 2025, the defendant failed to show for his ordered report, resulting in a warrant being issued for his arrest. And under general condition number 7, on August the 15th of 2025, the defendant tested positive for methamphetamines and amphetamines. The defendant denied use, and the sample was sent to the lab for confirmation. The sample was confirmed positive. And then again, on November the 19th, 2025, the defendant tested positive for methamphetamines, amphetamines, THC, and MDMA. The defendant admitted to these substances at that time.
All right, Mr. Howard, do you understand those allegations?
Yes, sir.
Excuse me, you have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you to a cost. Do you have the funds to hire an attorney?
No, sir.
Do you want me to appoint you one?
Yes, sir.
All right. Mr. Logs is going to hand you an affidavit of indigency that you need to sign for me this time. All right, court will find that you are indigent for the purposes of retaining counsel, and I'll appoint Attorney James Staton to represent you in this matter. The court further finds that there is probable cause you have violated the terms of your community control, and I will have this set for a final hearing. You'll be held in the Warren County Jail pending that final hearing. Thank you. Stephanie Hose. This is case number 22CR39959, the State of Ohio versus Stephanie Hose. Ms. Hose, the court has received a report that alleges that you have violated the terms of your community control. Officer, statement of the allegation, please.
Apologies, Your Honor. Give me a moment. It was not added. I will pull it up. Your Honor, under Special Condition 15, on November the 19th, 2025, the defendant self-discharged from the Monday program, resulting in her arrest.
All right. Ms. Hose, do you understand those allegations?
Yes, sir.
All right, you have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost.
I want to do an amendment.
You what?
I want to waive my right.
Have you talked to Officer Huff about this? Is that, I'm sorry.
It'll be Officer Rose, but...
I'm sorry, Officer Rose. Have you talked to Officer Rose?
Yes, I talked to Officer Rose. Do I have permission to speak?
I'm not sure that I'm going to resolve this today. I mean, I have her recommendation in front of me, but I want more, I need more explanation than what she's providing me in this email, to be honest with you. So I'm not going to resolve this for you today, regardless of what you do.
Okay.
Where do you live?
I'm from Cincinnati.
Okay.
The recommendation for the program, I did do the intake process. I was accepted.
You're talking about, you're not talking about Monday?
No.
You're talking about this first step?
Yes, sir. I did the intake process for that. I have a copy of the intake paper.
I understand all that, but again, I need more information from this officer than what she's provided me in this email, only because I ordered you to do something that you failed to do, and I want to know why I should change my position and let you do something that's really a lesser form of care than what had originally been recommended to me. That makes sense.
Sorry. Yes, sir. Then that's because my child is involved. She's 5 months old, and I'm trying I'm working with CPS, trying to prevent her from going to foster care. That's what this is about. It's about my 5-month-old daughter that I'm trying to prevent from going to foster care. I have a permanent custody hearing in Hamilton County on December the 12th. And that was the only way for me to even get there, was to sign myself out from the Monday. And with this program, my child can be there with me.
Where is your child now? Is she in foster care?
She's in temporary foster care until I can get to her.
Again, I think that you need to, I mean, I don't know what to say. I'm not really not inclined, because first step. So what happens on the December 12th? It's the juvenile court.
They will take her. They will grant.
They didn't let me finish my question.
I'm sorry.
If you're not there, that's what's going to happen. I get that, right?
Yes.
What happens if they say, you go to this hearing and they say, no, that's not in the child's best interest to let the child go with you to this drug rehab program? What's the situation then? Because honestly, that's what I view as the most likely scenario, that the court's not going to allow your 5-month-old child to go to a drug rehab facility with you. That's just, I'm just.
in this
I
screening.
know
that
that, I
did.
know that First Step's going to allow it. That doesn't mean the court's gonna allow it.
But that was the purpose of my CPS worker contacting the Monday and my probation officer so that I can be at
Okay,
that program.
Okay. But again, I'm not going to resolve this today. My recommendation to you is that you let me appoint your counsel, and I'll get this back on the docket next week, before the 12th. Because right now, when somebody refuses to do a CBCF for me, my initial response is either I'm going to send you to prison or you're going to do 6 months in the local jail. That's my initial response. And I'm trying to give you the benefit of the doubt and understand that there may be circumstances here that I should do something different, because this was ordered to help you. It wasn't ordered just to occupy your time or to. It was designed to help you. It was the level of care that was recommended to me in your PSI originally. So I think you need to talk to counsel. What I'm suggesting to you is that I want more information, and I'm willing to give you an opportunity to present that to me, but I'm not going to just do it on what the information I have right now. I'm not going to do that, okay? Let me appoint you an attorney. I'll set it for a hearing at the beginning of next week. Okay?
Not there.
Hang on. All right, the court will find that you're indigent for the purposes of retaining counsel, and I'll appoint Attorney Ben Swift to represent you in this matter. There is probable cause that you have violated the terms of your community control, and I'm going to set this for a hearing, and I'll have Jennifer set at the very beginning of next week, okay?
I'm gonna sit in jail till then.
Yeah. I mean, I really want more information than what you're able to provide me today. So I want to talk to Miss Officer, is it Sukavecki?
It's Rose.
I want to talk to Officer Rose, okay? All right, thank you. Brinson? This is case number 24CR41909, the State of Ohio versus Deshaun Brinson. Mr. Brinson, the court has received a report that alleges that you have violated the terms of your community control. Officer, could you read a statement of that allegation, please?
Yes, Your Honor. Under general condition number 5, on January the 25th of 2025, the defendant cut off his electronic monitor, and as a result, a warrant was issued for his arrest. And under general condition number 7, on November the 27th of 2024, the defendant submitted to a drug test that provided a dilute sample. And on July 16th of 2025 and November 20th of 2025, the defendant tested positive for marijuana. Under general condition number 12, at this time, the defendant has failed to pay his restitution as ordered by this court. And under general condition 13, at this time, the defendant has failed to enter and successfully complete outpatient drug and alcohol treatment as ordered. Under special condition 15A, at this time, the defendant has failed to complete the thinking for a change as ordered, and has also failed to obtain his GED as ordered from this court.
Okay, Mr. Brinson, do you understand the allegation?
Yes, sir.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
Yes, sir.
Do you want me to appoint you one?
Yes, sir.
All right. Mr. Lawson is going to hand you a form. It's an affidavit of indigency that you need to sign for me, please. All right, the court will find that you are indigent for the purposes of retaining counsel, and I will appoint Attorney Richard Wendell to represent you in this matter. There is probable cause that you have violated the terms of your community control in this matter will be set for final hearing. You'll be held in the Warren County Jail pending that final hearing. Thank you. Brown? Case number 24CR42078, State of Ohio versus Hussein Brown. Mr. Brown, the court has received a report that alleges that you have violated the terms of your community control. Officer, a statement of that allegation, please.
Yes, Your Honor. Under general condition number 13, on November 20th of 2025, the defendant was unsuccessfully discharged from the Hope House, resulting in his arrest.
All right, Mr. Brown, do you understand the allegations?
Yes, sir.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
No, sir.
Do you want me to appoint you one?
No, sir.
Where are you going to be living?
That was my problem with Judge Tepe. It's just the ankle monitor is the restriction. I was doing really good for you. I had completed 28 classes. I completed my thinking for a change. I had an interview with Courtroom Construction that I believe I got the job the Friday that I got arrested the Thursday. The Friday was for my third interview. It was a $60,000 to $80,000 position. I was telling you, I have really good background as far as jobs are concerned. Also, my theft class was about to be completed. It was a small disagreement in regards of the people and he was like the receptionist that was there. He was making complaints on the number of clothing that I was purchasing at Walmart. He said I was bringing too much inside of the Hope House. So I didn't give any people there any kind of problem in regards. It came to me as a shock that I was discarded.
Okay,
I have a place in Dayton, but it was not, I don't want to put myself in the hands.
I got to cut you off
Yes.
because I really have to deal with this attorney issue first.
Oh, yes, I'm sorry, sir. But no,
You
I don't want an attorney.
Okay,
at all.
Mr. Loggs is going to have
Yes,
you
sir.
hand you a waiver of counsel. You need to read it very carefully, okay?
Yes, sir.
All right.
Yes. Yes, sir.
All right, Mr. Brown, is that your signature?
Yes, it is, sir.
Did anyone promise you anything or threaten you in any way to get you to waive your right to counsel?
No, sir.
Are you under the influence of any drugs or alcohol?
Not at all.
Okay, so I'm going to put that you have waived your right to counsel. The court's going to make a finding you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and I will accept that. Now, with regard to these allegations, do you want to wait? You want to have a hearing, or do you admit to them?
No, I admit to being unsuccessfully discharged, but.
Okay. All right, I guess I'm trying to figure out. You were saying the monitor was an issue?
Yes, because if I don't have a place where someone else has right over me in regards, like if they tell me, like if I give you a friend's address where I could stay at or something of that nature, and then they were to call probation and say, I don't want him here anymore, it puts me in the same boat again. So if I didn't have the ankle monitor, which I was almost successfully done with, I was almost halfway through it. And
I'm not sure what I understand what the monitor has to do with anything.
It's just, it gives someone else who, for any reason, if they have a problem with me, they can.
That's not true, because if you're living with someone else and they have a problem with you, all you gotta do is they're gonna call probation and they're gonna do the same thing.
And
The
that's what I don't
monitor,
want. I'm
listen,
sorry. Yes, sir.
the monitor actually protects you because it lets us know that you are where you're supposed to be and not where you're not supposed to be. So it's actually a protection for you
But
in
it
that
was
sense.
something that was unnecessary. I was doing everything that was according to what was needed to be. I was gonna have the job. I was gonna have most of my restitution already paid by the time I got here. I've completed everything drug related that you asked or required of me. The thinking for change has been completed. I want to be able to have the freedom to have on my own shoulders to make sure that I can do the things that you have required without the courts having to have anyone that's involved. Because if that shelter would have never kicked me out, I wouldn't have had any kind of issues. Everything else that you were requiring of me was being done to completion with no problems at all. And I didn't even get a chance to talk to anyone in regards of why something as simple as me bringing in clothes from Walmart what constitutes them wanting to have me discharged when I never had any altercation, any egregious words with anyone. None of the problem. I was abiding by all their rules and regulations of the Hope House. So if I'm just able to be on my own, responsible for myself and my living, I will continue to do everything that you asked me, sir. I will have a job. I will go ahead and complete the theft class that is still required of me. I will pay the restitution of the $1,500 that is required of me, along with any court costs. I just ask for the opportunity, Mr. T, that you just allow me to be responsible for me. I'm 47 years old. On December 19th, you told me, hey, Mr. Brown, it's time for you to get back to work. It's time for you to stop thieving, stop having those problems. I've done the drug. It's things that you required of me, because I do admit to myself now also that, hey, my ideology of how I was believing about the drugs not affecting me wasn't the way it was. They were making me make simple and dumb mistakes continuously. And I don't feel that's the same mindset that I'm in. I have reconnected with my ex-wife and my kids. Like I spoke about my daughter last time. She's actually doing much better. And so I would like to, I asked Kara Fisher about even having my probation transfer to Missouri, but she said she was going to send to you in an email. But she said she also was going to just ask you about possibly no ankle monitor, or if you did feel that that was still necessary to coach a full circle. But I don't feel that those places like that are really what you need of me. I think you need for me to be a man, for me to stand on my own too.
If I release you from the jail today with no monitor, where are you going to go?
I have a lady friend that's more than willing to allow me to come to Dayton and finish out the things that I need to make sure I pay my restitution, to make sure I get
you're telling me a friend, but you provide me with an address. Where are you going to live?
Oh, I believe our address is 1093 Fair Oaks Lane in Dayton, Ohio.
This person's going to let you live there.
Yes, I mean, we become friends. At one time, we were like kind of a couple, but now we've become really good friends. I believe she actually has her kids and things of that nature. I didn't want to get into a relationship that way with her, so we amicably split and became more friends than any more romantic. But I spoke to her while I was at the Hope House, and she understands my situation. She at that one time, she wanted to see if I couldn't possibly, while I was at the Hope House, have things transferred there. But I just don't want to have that cuff on me in regards of
Nobody does.
I mean, but I think as of the cuff, just because if anything was to go wrong, instead of me being able to just find my own apartment or do something of that nature as I'm living there, a person can just have a bad day and say, you know what, I don't want you in my home anymore.
But that can happen. But again, that can happen whether there's a monitor or not.
I understand that, but at least it wouldn't violate me. I could leave the way it's supposed to and go to a hotel or make sure that they're aware.
That's not true. Your understanding of your obligations to report your change of address is mistaken.
No, I would have to let them know when she told me where I wasn't to go, but that would give me, if I'm working at the time, I could go and maybe get a in-town suite for a month and let them know where I'm going to be while I'm seeking an apartment, or it just gives me the freedom to be my own person, my own adult. I don't have to have someone else that's tied into that. I want to be responsible for me. I'm the one who committed the offenses. I feel I'm the one who needs to make sure I can take care of it without having any other one involved in it. So that's what I humbly ask you, is just to have a release today. Let me jump back into the boat I was and doing the things the way that I were doing, completing the classes, doing the job interviews. I believe I can have work within a couple weeks of my discharge easily, and go ahead and get back into the things that you were asking of me. My theft class to be completed.
Yeah, those weren't asks.
I mean, I'm sorry. The things that you told me needed to be done. Court ordered, sir, is the way it needs to be placed to you. Yes, the things that you ordered from me to have accomplished.
All right. All right, Mr. Brown, despite this violation, I will continue you on community control. All the previous orders still stand. I will order you released today. You are to get in contact with Officer Fisher immediately upon your release and provide her with the exact information of where you'll be staying. You need to engage in treatment. You need to engage in register for your theft class, you're thinking for a change and get this restitution paid.
Yes, sir.
Okay?
The thing
And
for a change
I'm gonna
has been
make a
completed.
note here that, because, you know, when the probation officers make a recommendation to me and I don't follow that, I hear about it later.
Yes, sir.
And I don't like to be wrong, so I have to try to gauge from here, you know, the situation.
Yeah, she was well
So
pleased with me.
again, you haven't been on supervision that long. It's only been, what, a month?
Yeah, it was
A little-
6 weeks into it. Yes, sir. But
So
I put
I'm
my
gonna make
best
a
foot
note
forward.
here that you talked me into this today.
Yes, sir.
So the next time you come back, if you have not done.
You won't see me again in this capacity, sir.
Well, people say that all the time,
I
and then the next
understand.
thing I know, they're back in front of me. So I'm just telling you.
Yes, sir.
It will be in my notes. All right, anything else? All right, that's all. Go ahead.
Thank you.
Who's gonna be handling the iPads, but I've got all the paperwork to get started.
All right, this is 22CR39959, the State of Ohio versus Stephanie Hose. You had something else you wanted to say to me?
Yes, sir. Well, upon speaking with my CPS worker, she was in contact with the program I was telling you about. She was trying to figure out. She had asked when my release date was, but I couldn't give her one. I just told her I had court today because she was ready to place me in a bed. So I'm not quite sure what to say to them.
What to say to who?
To the First Step Home, because
I don't care what you say to them, because, you know, they don't control things here. You know, the problem you have, Ms. Hose, with me, and I tried to explain this to you a minute ago, but you're not listening. You have a number of things going on, and your focus is over here on this juvenile court case. How many children do you have?
6.
And how many children have you lost to Children's Services already?
5.
So you have one left.
Yes.
Who's 5 months old. You don't have a great track record with juvenile court, and you're banking on, I order you to do a community-based correctional facility because that was the level of care that was recommended to me in the pre-sentence investigation. Do we agree on everything so far? Yes. Okay. So that's what I order. Generally, when I order someone to complete a lockdown facility, there's a reason for it. And if you don't complete it, if you get kicked out or you voluntarily say you're not going to go, there are consequences for making that choice. You don't get to pick and choose what the treatment is, because generally speaking, when someone has a drug problem, they're always going to choose the path of least resistance, which means they're going to do the least amount possible. Unless they really want help, then they're going to follow my orders and they're going to comply. And then they're going to get help. But you're banking on, as you stand here today, that this hearing in juvenile court on December 12th, that the court is going to go along with this idea that you're going to be sent to drug treatment and this 5-month-old child's going to go with you. I'm telling you, I'm not convinced that the court's going to go along with that.
Yes, sorry.
I'm not going to argue with you about this. I'm not going to dispose of this today. You don't get to pick and choose. Now, if your probation officer comes back here and she convinces me and your attorney convinced me that I should give you this chance, then I'm willing to consider it. But as I sit here right now, I do not have sufficient information to allow you to go to some sort of other treatment program when I ordered this program and you say, I don't want to do that one. For whatever reason, I don't care. Doesn't matter what your reason is. The bottom line is there was a substantial basis for me to order that level of care, and you have rejected that. So again, usually when that happens, I'm telling you that I send the person to prison, or at least at a minimum, they'll do 6 months, 180 days in the Warren County Jail, which means you will miss your hearing. So I'm giving you an opportunity now to present to me some additional information by appointing you counsel, and we will have a conversation the beginning of next week, well before December 12th, to see if we can make this work. again, those are your options. I mean, appoint you counsel, set it for hearing in less than a week, or go to jail for 6 months. I mean, what's your option? I'm not going to release you today because as I sit here and I've already told you, I don't have enough information before me. So I'm not going to do it. Okay? That's all. You had a question too? You have counsel.
It was just more about my case.
Yeah, I can't talk about your case with you without your attorney present. You need to talk to your attorney. Mr. Brenner, did he tell you when he got it set?
He said Friday.
Okay.
But what was my actual recommendation on probation?
Your Ariel?
No, I'm Aaron.
Your Ariel.
Your Honor, she was recommended for her judicial release to be revoked.
Well, there you go. You need to wait for your attorney. Thank you.